1611. That is people of the state of Michigan versus Kiana Brown Rios. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Net.
George Net, APD, on behalf of my client, who's sitting to my right.
And ma'am, you are Kiana Brown Rios. Is that correct?
Correct.
Right. Thank you. This is the time set for final pretrial today. Mrs. L, how we proceed?
Your Honor, at this time, the people are unable to proceed as the necessary witnesses have failed to appear. Subpoenas were sent for today's court date, and we have not had successful contact regarding the case itself. We have had brief contact with the complaining witness in this case, but we do not have a reason for their non-appearance today. We do expect a motion from defense at this time.
All right, Mr. Net.
Motion to dismiss without prejudice, Your Honor, and a copy of the Malley, please. Due to the circumstances the prosecutor stated on the record.
If Mr. Net, if we could draft you to grab the Nolly Cross on the printer. Yeah, thank you, Mr. Harris. All right, I'm in possession of a order of acquittal or Nolly Cross on docket 25-01611. Based on the defendant's motion, I'm going to grant the motion to dismiss without prejudice. It appears that people are unable to proceed. The complaining victim has failed to appear and was subpoenaed, and there's not been successful contact. I don't have a GPS. There's a no contact with Terrence Brown. So you should probably wait about 2 to 3 hours to let it purge itself from the system before. So make sure you carry around a Nolly Cross or dismissal. That you should, if you stay there, usually Miss Slaviak might be getting, Miss Slaviak is getting Mr. Cottenham. She'll provide you with a courtesy copy. And you should keep that courtesy copy with you, just in case. It takes about 3 hours. It has, yes. All right. Anything else for the record in 25-01611? This is dismissed without prejudice, which means that people could reissue if they choose to, but realistically, for our purposes, the case is dismissed. Anything else, Mrs. Hunt?
Not for the people.
Mr. Net. All right. If you stand by, you should get a copy of this. Probably a copy for your own records. And we're all set on that case.
Stick around there for your paper, then you're good to go.
Mr. Where are we going next?
I think we can head right to Mr. Carson.
All right. All right, so we're on the record in 25-01675. That is people of the state of Michigan versus Henry Carson. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezell, Assistant Prosecutor for the people.
Mr. Net.
George Net, APD, on behalf of my client, who's sitting to my right.
Sir, you are Henry Carson, is that correct?
Yes, Your Honor.
Thank you. This is time set for a final pretrial on this matter. Mrs. L, how we proceed?
Your Honor, at this time, the people's necessary witnesses have failed to appear. A subpoena was sent, but no successful contact was made with the complaining witness. We do expect a motion from the defense at this time.
Mr. Net.
Motion to dismiss based on the reasons the prosecutor stated on the record, Your Honor, that my client can get a copy. He has a GPS tether. I believe it's okay for him to go today to Mason and get it removed.
Yes. Let's have the Nolly Cross printed out. Mr. Harris will draft you again to.
Your Honor.
Thank you. Thank you, Mr. Harris. Mr. Carson, based on the prosecutor's representations of the complaining victims who have failed to appear in unsuccessful contact, I'm going to grant the motion made by your defense counsel to dismiss without prejudice, which means that people could reissue if they choose to, but realistically, for today's purposes, the case is dismissed. I do have a GPS as a part of this, you'll have to go back to Mason to get that taken off at the sheriff's department. And we'll email the private institution who's responsible for the GPS to let them know you're coming, okay? There's also no contact, no contact. I would let about 3 or 4 hours to let that purge from the system. So you should probably keep an order of dismissal with you, okay? And you can get a copy from my court officer. Right, anything else for the record in?
Nothing further on, thank you.
That's right, Memo. Anything else for the record, 2501-675, Mrs. L.
Not for the people. Thank
All
you.
right, thank you, Mr. Edney, you're all set. And you should get a copy of that for your record. I think the prior dismissal,
Yeah,
you got it, okay. And then Mr. Carter, do you need a chance to talk to Mr. Cottonham?
No, I don't.
Okay. Mrs. L, you ready to go on, Mr. Cottonham?
I am, Your Honor.
All right, so we're on the record in docket 24-01404. That is people of the state of Michigan versus Darren Cottonham. Will the parties please introduce themselves for the record, Mrs. L?
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Carter.
May it please the court, David B. Carter Jr. on behalf of Mr. Cottonham, who is present standing at council.
And sir, you are Darren Cottonham, is that correct?
That's correct.
All right, thank you. This is the time set for a final pretrial in the matter. Mrs. L, how we proceed?
Your Honor, it's my understanding that we will be setting this for a jury trial. An offer was extended today. That offer would be to plead guilty to count 1, domestic violence. Upon successful plea to that count, we would be dismissing count 2, domestic violence, and we would be agreeing to the specialty status of 7694A. At this time, it's my understanding that Mr. Cottonham wishes to take this to jury trial instead of taking that offer.
All right, is that a fair statement, Mr. Carter?
It is, Your Honor. I've had the opportunity to discuss this matter with my client. I've had the opportunity to discuss the pros and cons of accepting that offer. Mr. Cotton maintains his innocence and wishes to proceed to trial.
All right, thank you. So we will set this for jury trial on.
I think this is too fast for Mr. Carter. July 29th is our next date.
Would July 29th work for your schedule, Mr. Carter?
No, it does not.
All right, let's go out. I would say out a little bit.
August 26th at 8.
August 26th at 8 o'clock.
I will do my best to make that work. I'll take it.
All right, August 26th at 8 o'clock. For jury trial. So we've set this for August 26th at 8 o'clock for jury trial. Jury instructions will be due the week before as usual. And then Friday will be the cutoff date for any type of offer. I think Monday is on Tuesday. Monday is the cutoff date for any trial time due to the policy. It'll be a Monday night as opposed to a Friday on a Fridays for Mondays purposes. That's whether we need the jury trial or not. That's by policy set by the chief judge, as you know. All right. Anything else for the record in 24-01404, Mrs. L?
Not for the people.
Mr. Carter.
My client wishes for me to address bond. He indicated to me, and I have not been able to verify this, that he did turn himself in on the warrant. Your Honor set a $400 bond with GPS tether, I believe it was. My client is not able to come up with the $400 and wishes to convert that into perhaps a lower or PR bond.
Thank you. Mrs. L.
Your Honor, I do have concerns with the lowering of the bond in this case, specifically with the failures to appear that we have had in this case before. The complaining witness and other witnesses in this case have been pretty consistent about appearing and being here. Just for Mr. Cottingham to not appear at this time, Your Honor, we would ask that bond remain the same.
All right, I have a bench warrant was issued on June 10th, 2024. And then a bench warrant was issued on December 16th, 2024. That's December. It's December. Then I have a bench warrant was issued on February 25th, 2025. So based on the fail to appears, I'm going to deny bond at this time.
My client did want the court to be aware that he has served 24 days as of today regarding turning himself in.
All right. And on the current bench warrant, so that current bench warrant was issued as of June 19th. That would be about the 24-day period. Is that correct?
Yes.
All right. A bond is denied in this matter, and we'll see everybody here on August 26th.
When you say bond is denied, the motion to modify is
Correct.
denied.
Motion to modify bond is denied.
Thank you.
See, Mr. Carter.
All right. I'm next door, so I'll swing by and pick up.
Okay. Mr. Harris, what are you ready?
I am ready on Mr. Williams, as well as Tiara Adams, Joshua Carter, and Johnny Higgins.
Post. Right, so Mrs. Zell, are you ready to proceed on Williams and Adams?
I am, Your Honor.
Let's go on those.
And I believe Ms. Thompson's going to be handling the Adams case today.
Oh,
I will,
that's-
I can email me.
all right, that's Ms. Thompson. All right, so let's go on Timothy Williams. So we're on the record in docket 1700687. That is people of the state of Michigan versus Timothy Williams. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harries, here on behalf of Mr. Williams, who is standing to my right, Your Honor.
Sir, you are Timothy Williams, is that correct?
Yes, Your Honor.
Right, thank you. This is the time set for a final pretrial today. Mrs. Zell, how are we proceeding?
Your Honor, at this time, the people's necessary witnesses have failed to appear. We have sent a subpoena for this court date, but we have not had any successful contact. At this time, we do expect a motion from the defense.
Mr. Harris.
Yes, Your Honor, given the failure of the necessary witnesses to appear and proceed with this case, we would be requesting a dismissal at this time. I would request a copy be provided to my client. Permission to approach, Your Honor?
Yes, please. Thank you, Mr. Harris. All right, I'm in possession of the order of acquittal or nollie pros on docket 170067687. Based on the prosecutor's unable to proceed in representations, complaining victim was subpoenaed and contact has been unsuccessful. So I'm going to grant the motion to dismiss without prejudice, which means Mr. Williams, the people could reissue if they choose to, but realistically for our case purposes today, the case is dismissed. I do have a no contact order as a part of this. So you should probably wait 3 or 4 hours to let the system purge it. I'm going to give, you should get a copy of the dismissal just to hold on your person, okay? All right, with that understanding, anything else for the record in 1700687, Mrs. L?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor. Thank you.
Thank you. And you can get a copy for my court officer that dismisses. Okay. So Ms. Thompson is doing Miss Adams.
Yes, Your Honor.
All right, so we're on the record in docket 23-03023. That is people of the state of Michigan versus Tierra Adams. Will the parties please introduce themselves to the record? Ms. Thompson.
Laura Thompson on behalf of the people.
Mr. Harris.
Sorry,
Or did
I have
you
to
want
invoke the
a
court.
motion?
I'd like to motion to practice under Michigan Court Rule 8.120. My supervisor is APA Gabrielle Eziel.
Okay, so that is granted, and you only have to make it one time today. Mr. Harris.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Ms. Tiara Adams, who is standing to my right, Your Honor.
And you are Tiara Adams, is that correct?
Yes, sir.
Right, thank you. This is the time set for a pretrial in the matter. Ms. Thompson, how are we proceeding?
We've been informed by the defense that the dog involved has died, but I defer to the defense at this time.
Mr. Harris.
Yes, Your Honor. When I spoke with Ms. Adams yesterday, she indicated that on the day of the incident, when the ticket was issued, the dog was actually her mother's dog. Her mother is also here in the courtroom today, and her mother was at work. She was visiting, and that's why the ticket was written in her name. However, she also indicated the dog has since passed away and is no longer with us. So I don't believe compliance is truly an issue at this point. I will also note, Your Honor, when I spoke with Ms. Adams' mother earlier this morning, she did indicate that before the dog had passed away, she had gotten the dog license and did have proof of that. At this point, I didn't necessarily know if that was necessarily as relevant or moot anymore, given the passing of the animal.
And your client's prepared to indicate that the dog has passed on the record.
Yes, Your
All
Honor.
right. Ms. Adams, you're prepared to indicate that the dog, and this is the dog Meatball, is currently passed as you know. Okay. So with that understanding, did you want to move to dismiss?
Yes, Your Honor.
Okay. So with the understanding on the record, the dog is no longer able to be licensed and therefore has come in compliance, unfortunately. And so we will, and this is on a ticket, we will dismiss without prejudice any ticket based on Ms. Adams' representations that the dog is passed on the record. If the dog is not passed, you understand there are consequences for that.
Yes, sir.
All right. Anything else for the record in docket 23-03023, Ms. Thompson?
Not for the people.
Mr. Harris?
Not from the defense, Your Honor.
All right. We'll dismiss without prejudice. We'll dismiss without prejudice the ticket. Ms. Adams, you should be all set.
Thank you.
Thank you. Carter?
Yes, Your Honor.
Joshua. And Mrs. Elber, are you ready to go on Mr. Carter?
I am, Your Honor.
All right, so we're on the record in docket 25-01774. That is people of the state of Michigan versus Joshua Carter. Will the parties please introduce themselves to the record? Ms. Zell.
Thank you, Your Honor. Gabrielle Eziel, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Joshua Carter, who's standing to my right, Your Honor.
And sir, you are Joshua Allen Carter, is that correct? Thank you. This is the time set for a pretrial in the matter. Mrs. Zell, how are we proceeding, or would you like to defer?
Your Honor, it's my understanding we're going to be setting this for a final pretrial.
That is correct, Your Honor. We will be requesting a final pretrial at this time. Additionally, my client just wanted to confirm something regarding his bond, as he does have a medical marijuana card. However, his bond conditions indicate no alcohol, drugs, or illegal controlled substances. He simply wanted to confirm that the court was aware he had a valid medical marijuana card and was permitted to use marijuana. He wanted me to address that on the record.
Yeah, I don't, who arraigned him? Because I don't know. Judge Ward. I don't know.
Okay,
I have for marking as G, no use of alcohol, marijuana, or illegal controlled substance. But I don't have, I know we usually cover that in probation, in our probation. I don't know if that's covered in Judge Ward's arraignments. Ferris, you might know if that's covered in Judge Ward's arraignment.
I think it does often come up, but I can't be certain.
I'm going to indicate that as long as you have a viable medical marijuana card, that it can act as a prescription for any type of medical marijuana. That's it. I'll write that the same. And I don't think I have to modify the bond. I just have to clarify the bond. And
Thank
so
you.
we'll clarify that a medical marijuana card is acceptable for non-legal use. So pending the pretrial on this, I would carry that card with you, okay? Just so you have it and you have it as proof if that ever comes up. So we've set this for final pretrial on
July 29th at 8:30.
July 29th at 8:30. All right, this is set for final pretrial on July 28th, 9th at 8:30. I've clarified if need be the medical marijuana situation concerning having any type of card for acceptable use or pharmaceutical use. Anything else for the record in 2501774, Mrs. Ellen?
Not for the people.
Mr. Harris.
Not for defense, Your Honor.
All right, Mr. Carter, we'll see you on that July 29th date. That final pretrial will be in live in person, just like today. Okay, sir?
Awesome, thank
All
you.
right, thank you. And then Hinton. All right, so we're on the record in docket 2501662. That is people of the state of Michigan versus Johnny Hinton. Will the parties please indicate their presence for the record? Ms. Thompson.
Laura Thompson on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Hinton, who is standing to my right, Your Honor.
And sir, you are Johnny Hinton, is that correct?
John.
Thank you. This is the time set for pretrial in the matter. Ms. Thompson, how are we proceeding?
It's my understanding that we're going to be setting this for a final pretrial.
And is that a fair statement, Mr. Harris?
Yes, Your Honor, that is correct. At this time, we would be requesting a final pretrial date.
Final pretrial set for
July 29th.
July 29th at 8:30. Mr. Hinton, that'll be live on the 6th floor City Hall, just like today, for your final pretrial on July 29th. All right, sir. Anything else for the record in 2501662, Ms. Thompson?
Not for the people, Your Honor.
Mr. Harris?
Not for the defense, Your Honor. Thank you.
All right, you're all set, Mr. Hinton. Thank you. I did have some. Mr. Maloney, what case are you here?
I'm on Mr. Reyes, who's behind me. We
That's-
don't have an interpreter again.
Cecilia Reyes.
Yes.
Let's
And
speak.
I'm asking, he has agreed to the offer.
You want to just set it for plea or?
Yeah, I was gonna ask the court, we could do it. If you did it for the 29th, I would try to have his assessment done by that day. So maybe
Yeah.
we could do a plea and sentence.
I don't have that we even,
Say,
We've been here once before, but again, it was.
two appearances for the record. Have I already done this?
No.
Nope.
Okay.
Not for this one.
Ms. Thompson,
Laura Thompson on behalf of the people.
Mr. Meadow.
Mike Manaloni on behalf of Mr. Reyes, who's standing to my right.
And sir, you are Ronaldo Cesario Reyes, is that correct? Is that a yes, sir?
Yes.
Thank you. All right, this is time set for a pretrial in the matter. Through some conversations, we're going to set this for plea based on We need an interpreter here for the plea.
Yes, sir.
Yeah, it is, it's not marked, it's marked in my register of actions, but it hasn't been marked on the file. And we're about 40 minutes into this, and we have no interpreter. So let's set this for plea. That will provide Mr. Mataloni a chance to get the assessment and also to see about probation in another state.
Yes, sir.
All right. So we'll set for plea on July 29th at 9:30. Is that your understanding, Ms. Thompson?
Yes, Your Honor.
All right.
And I'm also gonna let White Law know to send an interpreter also. I'd rather have two here than nobody here.
That's probably a good idea. We should have somebody here. We're supposed to have somebody here today, but the file's not marked. We'll make sure the file's stamped, but it wouldn't hurt. It wouldn't hurt to have somebody here. So let's set it for July 29th at 9:30. Anything else for the record in 240312, Ms. Thompson?
Not for the people. Your
Mr.
Honor.
Mataloni?
No, sir. Thank
All
you.
right, you're all set. We'll see you on that July 29th date. Okay, sir?
Thank you.
Thank you, Mr. Mataloni.
Thank you. Have a good day, everyone.
Yes, somebody in the room. It's somebody in the post.
He's in a breakout room. Sure.
Okay, perfect. This out for a second and then. Mr. Harris, what are you ready on?
I am ready on Miss Kendra Little. My understanding is that's going to be requesting a final
All
pretrial
right.
date to engage in compliance.
Yes. We're gonna give. All right, so we're on the record in 24022973. That is people of the state of Michigan versus Kendra Little. Will the parties please introduce themselves to the record? Mrs. L.
Thank you, Your Honor. Gabrielle Izal, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Kendra Little, who is standing to my right, Your Honor.
And ma'am, you are Kendra Little, is that correct?
Correct.
Thank you. This is time set for a pretrial in the matter. Ms. Izal, how are we proceeding?
Your Honor, at this time, it's my understanding that the defense is trying to be in compliance with this law by getting the license reinstated. At this time, we are asking for a final pretrial to be set probably 40 to 60 days out if the court is willing to give her time to do that. If compliance is not met by that date, we would be discussing other resolutions.
Is that a fair statement, Mr. Harris?
That is correct, Your Honor. I spoke with Miss Little. She indicated she is in the process of trying to get her license back. She's going to Secretary of State to see what is necessary and plans to do whatever she needs to get her license back. I have spoken with her regarding the proposed offer from the prosecutor's office, and she has indicated she would like the opportunity to try and engage in compliance to get her license back. So we would be requesting that final pretrial date about 40 to 60 days out to try and give her that chance.
All right, so for compliance purposes, we'll adjourn this matter. And we'll set at 60 days out. At least that'll give us the start of some time frame. But realistically, if you come back 60 days and say it's going to take till next
What
year.
it is I just have to call, there's a couple
All right.
different tickets I gotta set up some payment arrangements with, I think is what it is. So I just gotta make a few calls and figure that out.
All right, so we'll we'll adjourn the pretrial to. We'll make it. Sometime in September.
September 9th at 9. Yes, September 9th at 9.
So we'll set it for September 9th at 9 o'clock. And you should get a copy of that date from my court officer. We'll set it for September 9th at 9 o'clock and go from there.
All
Right,
right,
ma'am?
sounds good. Thank
Right,
you.
anything else for the record in 24022973? 7-3, Mrs. L.
Not the people.
Mr. Harris.
Not for the defense, Your
All
Honor.
right, Ms. Little, you're all set. Thank you for your.
Oh,
I'm not technically, not that I don't want to, it's
That's fine.
against court policy.
If I,
If you ask him on the record, if he gives me a
And Ingham Jail Post 1, you are Matthew Tuttle? Oh, is that a yes, sir? I don't know if I can hear him. You might want to get closer to the mic.
I guess.
We're not getting any sound. Oh, I can hear you. All right, we're gonna call your case in just a second. All right, sir? right, so we're on the record in docket 25-00223. That is people of the state of Michigan versus Matthew Tuttle. Appearances for the record, Ms. Thompson.
Laura Thompson on behalf of the people.
Mr.
Sorry,
Knight.
George and Ed, APD on behalf of my client, Mr. Tuttle, is appearing via Polycom today.
And sir, you are Matthew Tuttle, is that correct?
Yes,
All
sir.
right, thank you. And Mr. Ned, I know you wanted to inquire of your client concerning this matter. You may proceed.
Your Honor, there is going to be a no contest plea today to a retail fraud third that the prosecutor gave in lieu of the original charge. Upon speaking with Mr. Tuttle, he indicated to me that this is what he wishes to do. I just wish to widen hear him very briefly. Mr. Tuttle, can you hear me okay?
Yes,
Do you understand by pleading no contest, the court will treat this as you're pleading guilty for sentencing purposes?
yes,
Has anyone forced or threatened you to plead no contest?
no,
Has anyone promised you anything in exchange for your plea other than what's stated on the record?
no,
Do you understand that this is a conviction? This will be a conviction in this case that can be used against you in any other case or investigations?
yes,
Have you discussed with me how this plea might affect any open charges or future charges you may face?
yeah,
You still wish to proceed knowing that this could be used as evidence against you elsewhere? Do you hear me?
yeah,
I'm gonna repeat the question. Do you still wish to proceed knowing that this could be used as evidence against you elsewhere?
no, I do not.
Okay, well, that's the problem. Yeah,
Did you want to meet with,
I did.
Okay.
We discussed this.
So-
So what do you wish to do today?
Plead no contest.
Okay, well, it's important that you have to understand that by pleading no contest, the judge is gonna find you guilty.
I'm
And,
aware of that.
and you know that because of that, because of your no contest plea, this could be used against you, could be used against you in the future. In regards to investigations, criminal history, and a lieu of other things. Do you understand that?
Yeah, I'll withdraw that. No, not guilty.
Okay. We'll set a final pretrial hearing.
okay. So let's set for final pretrial. We'll set for final pretrial on
July 29th.
at 8:30,
July 29th.
July 29th at 8:30. All right, so we've gone ahead and set this for final pretrial, and offer's been made. It's been discussed and then rejected, and we'll set it for final pretrial on July 29th at 8:30. Anything else for the record in 25-00223, Ms. Thompson?
Nothing for the people.
Mr. Ned?
No, Your Honor. Mr. Tuttle, I'll see you on the 29th. They're gonna bring you over.
So you'll be brought over on July 29th for your final pretrial. Sir, you're all set. Thank you.
May I gather that, please?
You may. It's evident why you're putting that on the record. Did you want to meet with Mr. Jones or Miss Jones?
No, we're prepared. I'm prepared.
All right, Ms. Jones, we can call your case, so you can unmute. Carrie Jones?
Oh,
Oh,
Kari?
sir, Kari Jones. Have you met with Kari Jones?
I did last week,
Okay.
Your Honor.
All right, we're on the record in docket 25-01312. That is people of the state of Michigan versus Kari Jones. Kari Jones Jr. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Annette.
George and Ed, APD on behalf of my client, Kari Jones, who's appearing via Zoom today.
And sir, you are Kari Jones, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Jones?
Yes.
Thank you. This is the time set for a pretrial on this matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding we're going to be asking for this to be set for a final pretrial.
Correct, Your Honor.
So set for final pretrial on
July 29th at 8:30.
July 29th at 8:30. So Mr. Jones, we've set this for final pretrial on July 29th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. All right, sir?
Okay, thank you.
All right. So Zoom will be inappropriate for that final pretrial. Anything else for the record in 25-01312, Mrs. L?
Not for people.
Mr. Annette?
Mr. Jones, you have to be in person on the 29th. Did you hear that?
Yes,
All right, I'll give you a call before that time. Thank you.
okay.
So we'll see you on the 29th, Mr. Jones. You're all set. Thank you for your appearance today.
All right, thank you. Have a good one.
Or do we
I
not?
have no idea.
But
I'm just going to identify who's on the cell phone. Who's on the cell phone for identification purposes? You have 904-927-1506.
Oh, this is Natasia Baker.
Baker.
Yeah.
Tasia Baker. All right. And you're here for your 9
Okay.
o'clock, ma'am?
Yes, sir. Yes, sir.
Who's
it should be me, but I don't see. Give me one moment.
let me rename. Did you? Do you need to meet with Miss Baker?
I don't.
All right, Ms. Baker, we've renamed you. We just had the cell phone number for standby, and we'll call your case in just a second. All right, ma'am?
Yes, sir. Thank you.
That's why.
All right. Now
Ms. Baker,
Yes.
can you see me?
No, I can't see you. I'm on the phone, not Zoom.
Okay, can you hear me?
Yes, I can hear you.
Okay, this is your attorney. I'm still working on the offer that we talked about. We're gonna
Okay.
leave a separate file on pretrial this time. It's gonna be in person. So we're gonna get a court date from we're gonna get a court date from the judge here in a minute, and you have to come in person, okay? We're still working on that the offer we talked about.
Okay.
All right. All right, so we'll call your case, Ms. Baker. We're on the record in docket 18-06451. That is People of the State of Michigan versus Natasha Baker. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the People.
Mr. Annette.
Thank you, Your Honor. George and at APD. On behalf of my clients appearing via Zoom today.
And ma'am, you are Natasha Baker, is that correct?
Yes.
And you can hear me all right, Ms. Baker?
Yes.
All right, this is the time set for a pretrial in the matter. Mrs. L, how we proceed?
Your Honor, at this time, we are asking for this to be set for a final pretrial. The offer that we extended at the last pretrial was that we were considering getting this case back into diversion. I have not had the opportunity to seek that permission to get the case back into diversion, but we'll do so before that final pretrial.
All right, and is that a fair statement, Mr. Annette?
Yes, Your Honor.
All right, we'll set for final pretrial on
July 29th.
July 29th at 8:30. That, Ms. Baker, that final pretrial will be live in person on the 6th floor of City Hall of Lansing. All right, ma'am?
Okay.
All right, anything else for the record in docket 18-06451, Mrs. L?
Not for the People.
Mr. Annette?
Yeah.
All right, I'll see you on July 29th at 8:30. Ms. Baker, you should be all set.
Okay, thank you.
You're welcome. I'll place you in a room with Miss White. Ma'am, you are Kelsey White, is that correct? You're here for
Yes.
your 10 o'clock? All right. I'm gonna place you, I'm gonna place you in a room with your public defender, and he'll be in there once he joins, all right, ma'am?
Okay, thank you.
So you should get a prompt to go to room 2.
You get taken off.
Prompt to go to room 2.
Now you-
You are too fast.
No. I'm-
Oh, I see it now.
It's just a race, isn't it?
You go Michael
You
Mount.
made it a race.
Your Honor.
Me too. Michael Mountain?
Yeah, Bill's up here.
All right. That was a 9 o'clock, yep. All right. And Samantha Johns just,
We also have Mr. Hewitt here for his tickets.
okay.
I believe he is unrepresented today.
And have you met with him?
Ms. Thompson has.
All right.
yes.
Let's go on Mr. Mountain and then we'll call Mr. Hewitt. And who's representing Samantha Johns? Is that Mr. Harris or Mr. Annette? Samantha Johns. who just joined us.
Not me, yeah, Mr. Harris. Oh, that's me, Your Honor. I've had contact with her. After the failure to appear, I'll meet with her.
All right. All right, Ms. Johns, Samantha Johns, we're going to call your case right after we do, call another case, all right?
Yes, sir.
Okay. All right, so we're on the record in docket 25-00429. That is People of the State of Michigan versus Christopher Wilson. Will the parties please introduce themselves for the record? Mrs. O.
Thank you, Your Honor. Gabrielle Izzo, Assistant Prosecutor for the people.
Mr. Annette.
George and APD on behalf of my client who's not here today. You're not, I've not had contact with him.
All right, this is the time set for a final pretrial on the matter. This is scheduled for 8:30. It is now 10:03. And it would appear that defendant has failed to appear for the final pretrial. I do not see Christopher Wilson in the Zoom courtroom or in the physical courtroom, and nobody answers by that name in the hallway. It would appear that the defendant has failed to appear for the final pretrial. Mrs. L, how would you like to proceed? I have a bench warrant was issued on June 3rd with a 48-hour hold on Mr. Wilson. I don't know if you have that same information.
I do have that same information, Your Honor, and at this time, based on that prior failure to appear in that prior bench warrant, we would ask for an immediate bench warrant in this case.
All right, and as indicated, Mr. Ned, you've had no contact with Mr. Wilson.
Okay, I just had a podcast with him last week, and then shortly after I set that up, minutes later, I got information he was released from custody somehow.
So an immediate bench warrant is issued based on the non-appearance. Anything else for the record in 25-00429, Mrs. L?
Not for people.
Mr. Annette?
Yeah, thank you. Giants.
So Mr. Annette, you can make this challenge, right?
Sir.
I'll let you.
I thought you were gonna.
Yeah, I know, I'm not gonna. I'll lose.
With that attitude, for sure.
Did you want to go on Mr. Hewitt?
Yes, Your Honor, we could.
All right.
I believe he has 2 ticket cases today.
3, I have 3 tickets today. All right, Mr. Hewitt, you can come up here. 6, 7. Five, 9, 6. All right, so we're on the record in docket 25-01556, 25-01557, and 25-01596. Will the parties please indicate their presence for the record, Ms. Thompson?
Laura Thompson on behalf of the people.
And sir, you are Patrick Hewitt, is that correct? Yes, sir. All right. And Mr. Hewitt, you're here on all 3 files, is that correct? Yes. All right, thank you. This is time set for pre-trial on all 3 files. Ms. Thompson, how are we proceeding?
We've offered Mr. Hewitt to plead guilty to one of the tickets, and we would dismiss the other 2. With costs and fines for the ticket he would be pleading guilty to.
All right. Is there a Killebrew agreement of no jail between the parties then?
Yes, Your Honor.
All right. And is Mr. Hewitt going to accept the offer today?
It is our understanding.
Okay. All right. Do you know what file Mr. Hewitt will be pleading to?
He will plead to file number 25-01652.
I don't have that file.
That's Amanda Jones.
Oh.
How about either 556, 557, or 596 are the 3 I have.
Those are just simply different numbers in our system, and that's typically how it is with ticket cases.
All
It's
right.
fairly confusing. We have no preference of which ticket is pled to,
All right.
just one out of the 3.
I think there's 2 on 1 ticket. That's the 556 and 557. Let me just make that just for sure. And then one separate ticket.
Yes, Your Honor.
All right. So let's do the separate tickets. I'll walk you through that. Your understanding, sir, is this is a misdemeanor. It's this is punishable for by 90 days and or 200, 500. A misdemeanor is punishable by 90 days and or $500. Do you understand that, sir? There's an agreement between yourself and the prosecuting attorney that you receive no upfront jail and we go to immediate sentencing. Is that correct?
Yes, Your Honor.
Perfect. All right. And my understanding is that with a plea to that ticket, and it's almost easier to use, with the plea to the ticket on 2501-596 having to do with Oreo tickets, the two tickets on 556 and 557 are to be dismissed. Is that also part of the plea agreement? All right. All right. You have some rights in this misdemeanor matter, and I'm going to walk you through those rights. All right. You have the right to be tried by a jury, to be presumed innocent or proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses are brought against you, to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we put on the record, or threats that it was not your choice to plead guilty. You're also giving up the right to appeal anything from trial, since you won't be having a trial on the ticket involving Oreo, a dog at large ticket. Is it still your wish to plead guilty, waive your jury trial rights, and plead guilty to that file, Mr. Hewitt?
Yes.
Okay. I'm going to have you raise your right arm, right hand as best you can. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Okay. I'm going to bring your attention, sir, back to May 27th of 2025 at the offense location of 135 West Howe Avenue in the city of Lansing. Were you at the West Howe Avenue address on May 27th, 2025? And were you a guardian, or were you in charge of a pit bull mix by the name of Oreo? And was Oreo not on a leash or at large on that day? Yes. Okay. And you knew Oreo was at a time during the day, you knew that Oreo was not on a leash or at large on that day. Yes. Okay. Anything towards a factual basis, Ms. Thompson?
No, Your Honor.
All right. So we'll go right to sentencing. Ms. Thompson, was there any restitution on this matter?
No, Your Honor.
Okay. Did you want to say anything? I know you've entered in a Killebrew agreement of no jail. Did you want to say anything on behalf of the city, of the people?
No, Your Honor.
All right. Mr. Hewitt, is there anything you'd like to say to the court before the court passes sentence concerning your immediate sentencing on the dog at large? Okay. I'll follow the recommendation or the Killebrew agreement. So I'll order no jail. We'll set fines at costs at $100. Crime victims' rights fee of $75 and state fee of $50 for a grand total of $225. And do you need that time to make that payment to the city of Lansing, Mr. Hewitt?
Yes, I do.
90 days?
That would be fine.
Okay. All right. So 90 days to the city of Lansing.
October 15th.
So it'll be October 15th. And that'll be $225. You can pay online, in person, or by phone. As long as it's all paid by October 15th, you can kind of set up your own plan.
I was gonna say I can make partial.
Yeah, you can mark page. You could pay a weekly amount or monthly amount. They'll have all that information at the window. But as long as it's all paid by October 15th, you should be set. All right. As a part of this plea agreement, we will dismiss 25-01-557. And we will dismiss 25-01-556. All right, anything else for the record in 25-01-596, Ms. Thompson?
Nothing, Your Honor.
Mr. Hewitt, do you have any questions of me? All right, you should be all set, sir. Thank you for your participation.
Yeah. Have a good day.
You too. All right, in Ingham Jail Post 2, Visit 3, is your name Toby Radcliffe? Or Jacob Sewell Lopez?
Yes, Your Honor, Jacob Sewell Lopez.
All right, thank you. Unmute. Okay.
Ms. Johns?
Yes.
I'm gonna give you a call today again. If you don't answer, then just appear in court on the next court date. We're about to get here in a little bit.
Okay.
So I'll try to give you a call today, hopefully.
Okay. So do I leave or what do I do?
No, stay. Actually, can you text her my number?
Yeah.
My phone number is, they're gonna put my phone number. I want you to call me at the end of the day because your mailbox is full and I don't know if I'm gonna be able to get a hold of you.
Okay.
Is that possible?
Yes, I will do it for you this one time.
No, it's, I can put on, I can do it early.
It's okay. It's okay. You already told me.
Well, you can put it on the record too.
Yeah, I just put on the record. I just don't want, I don't know if it's easier.
Not your secretary.
All right, so you're ready on John's, and Miss Thompson or Mrs. L, who's gonna handle Miss Samantha Johns?
That will be me.
All right. All right, let's call that. So we're on the record in docket 25-01652. That's people of the state of Michigan versus Samantha Johns. Will the parties please introduce themselves to the record? Ms. Thompson.
Laura Thompson on behalf of the people.
Mr. Annette.
George and APD, on behalf of my clients appearing via Zoom today.
All right, and ma'am, you are Samantha Johns, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Samantha Johns?
Yes.
All right, thank you. This time is set for a pretrial in the matter. Ms. Thompson, how we proceed? Or would you like to defer to Mr. Annette?
I'll defer to Mr. Mayor.
Yeah, we're gonna leave separate file pretrial. An offer has been conveyed from the prosecutor. If Ms. Johns brings proof that her dog, the dog is no longer in possession, there'll be a dismissal. And if the proof is not sufficient but acceptable, it'd be a civil infraction.
All right, and then and Ms. Johns has your contact information, Mr. Annette.
No, you're Ms. Johns, can you take my number down real quick?
Yeah.
517
Okay.
679
Okay.
2975. Please give me a call around 3 o'clock today if you can.
All right. Sounds good.
All right, we'll set this for final pretrial on July 29th at 8:30. All right, so Ms. Johns, I will, if the court hears that we need the hearing, we'll set it for final pretrial on July 29th at 8:30. That'll be live in person on the 6th floor of Lansing. All right, ma'am?
All right. Sounds good.
All right. Anything else for the record in docket 25-01652, Ms. Thompson?
No, Your Honor.
Mr. Annette?
Thank you.
All right, Ms. Johns, you're all set. Thank you for your appearance tonight.
All right. Thank you. Have a great day.
You too. And I don't know if you've met with Miss White. Uh, on Mr. Ogletree, are you here on Keegan Mowbray? We have that set for 1:30 this afternoon. All right, so let's go on the record on Miss White. All right, so we're on the record in docket 25-01819. That is people of the state of Michigan versus Kelsey White. Will the parties please introduce themselves to the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Miss Kelsey White, who is appearing via Zoom, Your Honor.
And ma'am, you are Kelsey White, is that correct?
Yes.
All right, you can hear me all right, Miss White?
Yes, sir.
Thank you. This is the time set for a pretrial in the matter. Mrs. Zell, how are we proceeding?
Your Honor, it's my understanding that at this time, we're going to be asking for this to be set for a final pretrial.
Is that a fair statement, Mr. Harris?
That is correct, Your Honor. We would be requesting a final pretrial date at this time.
All right. So we'll set for final pretrial on
July 29th at 8:30.
July 29th at 8:30. Ms. White, that'll be a live final pretrial on the 6th floor of City Hall of Lansing. A Zoom would be inappropriate for that event. All right, ma'am?
What day?
It's July 29th at 8:30.
Okay.
You'll get a copy of that notice in the mail, Miss White.
So you'll get a copy sent to the Duvray Drive event, Duvray Drive address. Is that still a good address for notification purposes?
No.
Do you have an address that you would prefer for notification purposes?
Yes.
And what address is that, ma'am?
4245 West Jolly Road, Lot 217.
And what's the zip code there, ma'am?
48911.
All right. We'll send the notification to that address, and that would be your updated address. Is that correct?
Yes, sir.
All right. All right, that'll be on July 29th at 8:30. Anything else for the record in 25-01819, Mrs. Zell? Mr. Harris.
Nothing in defense, Your Honor.
All right, you're all set, Ms. White. Thank you for your appearance today.
Thank you.
And Mr. Harris, did you want to be put in?
Yes, with Mr. Swarlow, please, Your Honor. Thank you.
All right, so Mr. Sewell Lopez, I'm going to put you in room 2, and then you'll be joined by your public defender. All right, sir?
Okay.
I was supposed to put George's in there.
With Kylie?
Yeah. But
Should I come back?
Mr. Ogletree, you're here on Mr. Mugray.
We are ready on the Brandis case, which was a 9 a.m. That's going to be a failure to appear.
All right.
As well, I'm also ready on Mr. Fidel and Suel Lopez, who I believe would need to be brought back from the breakout room as he is on the Polycom device.
Takes a second. All right, let's call Mr. Brandeis. All right, so we're on the record in docket 25-01751. That is people of the state of Michigan versus Lee Brandis. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
And is that your case, Mr. Harris?
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Mr. Lee Brandis, who unfortunately does not seem to be here in person or via Zoom. His case was scheduled for 9 a.m. It's now about 10:43. I tried to make contact with Mr. Brandis yesterday and was unable to, but left a voicemail with a courtesy reminder of the date and time of the court date. I tried calling him again this morning after the failure to appear to see if there was an explanation for the failure to appear, and again was only able to leave a voicemail. At this time, I do not really have any explanation for his failure to appear, Your Honor.
All right. This was, as indicated previously, this was set for 9 o'clock. It's now 10:43 or 44. And it would appear Mr. Brandis is not in the Zoom courtroom or physical courtroom. It would appear nobody's answered by that name in the hallway. And based on the representations of counsel, it appeared that defendants failed to appear for the pretrial today. Mr. Harris indicated he has not any successful contact with Mr. Brandis. Mrs. L, how would you like to proceed?
Your Honor, at this time, we would be asking for a bench warrant to be issued in this case. This is a non-assaultive case, and there have not been any prior failure to appears in this case. So we would not be against a 48-hour hold if the court is inclined to agree to that.
Thank you, Mr. Harris.
If the court would consider adding a 48-hour hold on this case, I would request for that, Your Honor. And I will try again to get in touch with Mr. Brandis regarding the 48-hour hold.
All right. For the defendants failed to appear, I have no previous fail to appear. This is a non-assaultive case. So we'll issue a bench warrant with a 48-hour hold. Anything else for the record in 25-01751, Mrs. L?
Not for the people.
Ms. Harris?
Not from the defense, Your Honor.
Thank you. And then I think we brought back
Yes,
Mr.
I believe
Sewell.
Mr. Suel Lopez is currently present.
Let's go on to Sewell Lopez. All right, so we're on the record in docket 25-01841. That is people of the state of Michigan versus Jacob Sewell Lopez. Will the parties please introduce themselves for the record? Ms. Thompson.
Laura Thompson on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Jacob Sewell Lopez, who is appearing via Polycom from the Union County Jail, Your Honor.
And sir, you are Jacob Sewell Lopez, is that correct?
Yes, Your Honor.
All right. And you can hear me all right, Mr. Sewell Lopez?
Yes, Your Honor.
All right, thank you. This is the time set for a pretrial in the matter. Ms. Thompson, how are we proceeding today?
It is my understanding that we will be setting this for a final pretrial.
Yes, Your Honor, that is my understanding as well. I've spoken with Mr. Sewell Lopez regarding this case and regarding the potential offer. At this time, we would be, he has indicated he would like to have this case set for final pretrial.
All right, we'll set for final pretrial on
July 29th.
July 29th at 8:30. All right, that'll be live on the 6th floor of City Hall of Lansing for the final pretrial on July 29th at 8:30. Anything else for the record in 2501841, Ms. Thompson?
No, Your Honor.
Mr. Harris.
Possible, Your Honor. I do note that is the bond correctly stated at the 2010%?
That's the last I see for bond.
My client has been sitting in custody. He asked if I could potentially try to address bond on his behalf.
You may proceed.
Your Honor, my client is willing to abide by all the terms of his bond. At this point, he is rather indigent and does not believe he would be able to post that 2010% bond. At this point, he is also aware that I believe there is a requirement for a GPS tether. I have spoken with him about the grant that could potentially cover the cost of the GPS tether if he is indigent. At this point, I would be requesting that the court consider either the lowering the bond to lower 10% bond, something he could possibly post, or consider converting it to a PR bond, Your Honor. Mr. Sewell Lopez has indicated to me that if he was released, he has every intention to follow all of his bond conditions. I don't believe there's been any allegations that there's been any issues or any contact. I realize he has been in custody, but my client still wished for me to ask.
All right, thank you. Response from the people.
We request that the bond remains the same, Your Honor.
All right. I set bond at 2010%. So I set a lower 10% bond as it is. I'm unwilling to go lower than that today. So the motion to reduce bond is denied.
Thank you, Your Honor.
And we will set this for July 29th at 8:30. That's all for the record in 2501841. Thank you for your appearance today. You're all set, Mr. Sewell.
Thank you, Your Honor. Thank you, James.
Thank you.
Thank you, sir. Good luck to you.
All right, Ms. Cross, we'll call your case. You can unmute. All right. Thank you, Ms. Cross. We're on the record in docket 2501361. That is People of the State of Michigan versus Eileen Cross. Will the parties please introduce themselves for the record? Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Nunn.
Thank you, Your Honor. George and APD on behalf of my clients are appearing via Zoom today.
And ma'am, you are Kylie Cross, is that correct?
Yes,
And you can hear me all right, Ms. Cross?
yes.
Thank you. This is the time set for a pretrial in this matter. Mrs. L, how are we proceeding?
Your Honor, at this time, the people will be asking for this to be set for a final pretrial. We believe that the offer that has been extended as charged with TIDA is the only offer that will be extended at this time. So we believe moving forward to the final pretrial would be the next best step. I will defer to Mr. Anid for his record.
All right, Mr. Ned, request is for final pretrial. Is that a fair statement?
Yeah, I had a meaningful conversation, a very brief conversation earlier today with my client. We were unable to conduct an initial consult. We have decided to conduct that this week, so we are okay with the final pretrial to get this case moving along. I explained the offer, the height of status, and I'm gonna go in more detail today when we actually have our consult. So although we didn't have a consult prior to the pretrial, we'll be conducting one this week. Just to let the court know if for whatever reason there are any errors or issues, we might ask for another final pretrial, but I don't think it's gonna be necessary.
All right. We'll set for final pretrial on
July 29th at 8:30.
July 29th at 8:30. So Ms. Cross, that'll be live in person on the 6th floor of City Hall of Lansing. All right, ma'am?
Okay.
All right. So we've set it for July 29th at 8:30 for final pretrial. Anything else for the record in 25-01361, Mrs. L?
Not for the people.
Mr. Annette?
Oh, yeah.
All right. Ms. Cross, you're all set. Thank you for your appearance today.
Thank you.
I don't see Shanika.
Oh, here we go. Talk to right now.
That's Miss Hatz.
Oh.
Who's Mr. Ned or Mr. Harris? Who's representing? Okay, Mr. Ned. Miss Hatz is right behind you. And then you heard anything from Radcliffe?
I have not.
You should be.
We've got time.
Holly? Yeah.
Radcliffe should be on phone.
Yes, sir.
You know. Sir, are you Toby Radcliffe?
Yes, I am.
All right. Stand by. We're going to call your case in a second. I may have you meet with the public defender before your case. All right, sir?
Yes.
All right, so Mr. Radcliffe, I'm going to place you in a breakout room with your attorney. So you should be in room 1 when he joins, okay?
All right, thank you.
I tell me the assistant's, the attorney's name.
Elizabeth. Machi?
Doesn't sound any better than I was doing. What did you say, Mr. Harris?
Crockmolney.
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 Crockmolney. She's got to send that email. It's just like a visual pronunciation. Ms. Thompson, you're doing fine. It also helps to have a name like Thompson, because we've had a city attorney this last week's, and I cannot pronounce her last name. And I've tried. I wrote it out. I've tried. And every time I mess it up. It's easy to mess up, but it's not that hard. Okay. Crockmolney. Is that right, Mr. Grace?
I believe so, yeah.
Am I the only judge who has a problem with that?
I'm not sure. I mean, I know when I was over in Judge Ward, there were a couple of times where I would make a little sticky note with just phonetic pronunciations of certain things.
They don't seem to help me. I don't know. I think the email from her explaining, or just seeing her name, maybe.
Judge, we're not muted, just so you know.
All right, Mr. Radcliffe, we'll call your case. We're on the record in docket 25-00649. That is People of the State of Michigan versus Toby Allen Radcliffe. Appearances for the record. Who's Mrs. L?
Sorry. Thank you, Your Honor. Gabrielle Izal, Assistant Prosecutor for the People.
Mr. Ned.
George Net, APD, on behalf of my clients, it was appearing to be a polygon today.
And sir, you are Toby Allen Radcliffe, is that correct?
Senior suffix, yes, sir.
Is that a yes?
Yes.
Is that a yes, sir?
Yes, sir.
All right, thank you. And Mr. Radcliffe, you can hear me all right?
Yes.
Thank you. This is time set for a pretrial in the matter. Mrs. L, how are we proceeding?
Your Honor, it's my understanding that we're going to be asking for this to be set for an additional pretrial. It's my understanding that Mr. Radcliffe will be being released from custody shortly, and then he hopes to become in compliance with the law regarding his license as soon as he is released. I will defer to Mr. Need about the dates on that to see if we can get that pretrial set.
All right, Mr. Ned.
Yeah, I believe my client's being released next week on an unrelated file. I met with him last week on Polycom. That was my mistake. But I met with him last week. We discussed the file, discussed again briefly today. Should be released sometime next week. His plan is to comply for the offer of a potential dismissal, and if not sufficient, potentially a civil infraction is the hopes.
All right. So we can set this for second pretrial about like 30 days out?
I think that would work.
We don't even need that much time.
Okay.
Right?
So in that realm of 30 days or less.
August 5th at 9 o'clock.
I say that when knowing that I don't do the scheduling, so it's easy for me. August 5th at 9 o'clock. All right, so Mr. Radcliffe, that we've set it for second trial. You can attend by Zoom for August 5th at 9 o'clock. And please keep in contact with your attorney, Mr. Ned. Anything else for the record in 25-00649, Mrs. L?
People.
Mr. Ned.
Yeah, thank you.
All right, Mr. Radcliffe, you're all set. Thank you for your appearance today.
Have a great day.
You too. And let's call on Miss Davis. So we're on the record in docket 25-01437. 25-01542. That is People of the State of Michigan versus Shanika Davis. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Izal, Assistant Prosecutor for the People.
Mr. Annette.
George Net, APD, on behalf of my client was not here today.
All right, this was set for 10:30. It is now 11:15. I do not see a Shanika Davis in the Zoom courtroom or physical courtroom. Nobody's answered by that way in the hallway. And Mr. Annette, you've had no contact with Miss Davis?
Correct.
Okay. It would appear that the defendant has failed to appear for the pretrial. Mrs. L, how would you like to proceed?
Your Honor, since this is the first time we are here for this case, and it is just a dog license case, we would be asking for a courtesy reset at this time.
Right, we'll do a courtesy reset on both these files.
July
On,
29th at 9:30.
say it again.
July 29th at 9:30.
All right, there have been no prior fail to appears in this matter. And these are both dog offenses or dog, they come from a ticket. So we will do a courtesy reset for July 29th at 8:30. Anything else for the record in 25-01542, For 25-01437, Mrs.
Not for the people.
Mr. Net.
Thank you.
All right, thank you.
Oh, smokes. That's shit.
Is Mr. Ray here?
I'm writing about it.
I do not believe Mr. Caleb Ray is.
I
here.
think he's in back.
Oh, perfect. Never mind. He's here then.
And is that your client, Mr.? Let's bring up Mr. Ray. I only do that because I know it's not a fact. I know it's happening on that one. All right, so we're on the record in docket 24-03-510. Appearances for the record. You're gonna have to help me with your name again.
Andrea Fodchuk,
And it's FODCCHUCK.
FODCHUK, Your Honor.
And then you can make your motion.
I'd like to make a motion under Rule 8.120 to practice in the courtroom today.
Okay.
My supervisor is Gabriella Zell.
Thank you. It's granted. And you only have to make it once. Mr. Ned.
George Ned, APDM, I have my client standing to my right.
All right, and sir, you are Caleb Ray, is that correct?
Sir.
All right, thank you. This has been brought to my attention. This is a time set for a probation violation. And then I had the opportunity to look and see what comments were made. And it appears that Mr. Ray has been in Eaton County, is that correct? Okay, I think your probation agent knows that. So what probation is requested is we dismiss the violations, and have you complete and have you back on the probation, back on the wagon. So you can go down, you can see when you're supposed to see Mr. Hanna and start whatever process was started. I think this happened during the course of while Mr. Ray was in Eaton County.
And we got the process started. We both went downstairs, met with,
Perfect.
so he knows what to do after this.
All right. So the probation violations have been dismissed. At request of the probation department. And Mr. Ray, Mr. Hanna, I know Mr. Hanna is going to work with you. Just have to stay on board, all right? And let him know any information, if you your whereabouts or anything else, because he needs to know, or else you're going to get another one of these, right, sir? All right. Ms. Fodchuk, any questions concerning this sentence? I have a note here saying the violation should be dismissed. Deed back to completing probation requirements.
No, Your Honor.
All right, Mr. Ned.
Thank you.
You're all set, sir. Thank you. Now we'll go back to Mrs. Zell and you can call whatever. We have Mr. Mowbray and Post.
Yes, if Mr. Ogletree is on Zoom, we would be able to go on that. Otherwise, I do believe we could go on Post. Ms.
All right.
Post is on Zoom.
I'm ready.
Mr. Ogletree, you're here for Keegan Mowbray. You'll have to unmute, sir.
Yes, I am, Your Honor.
All right, and is Mr. Mowbray, okay, you can come up here. And I think Mr. Ogletree asked for this was based on a no contest plea from May 20th, 2025. Is that a fair statement? You're gonna have to remind me of the name. Your name again.
Ms. Fodchuk?
Ms. Fodchuk, thank you.
Yes, Your Honor.
Or I'll forget. All right, so let's call to the record 25-00786. That is People of the State of Michigan versus Keegan Mowbray. Mr. Ogletree, your appearance for the record.
Aaron Ogletree, on behalf of Mr. Keegan Mowbray. 69167 is my P number.
And Ms. Fodchuk.
Andrea Fodchuk on behalf of the people.
All right, and sir, you are Keegan Mowbray, is that correct?
Correct.
All right. And you can hear me all right, Mr. Mowbray, is that correct? All right. This is a time set for sentencing the matter. Ms. Fodchuk, are you aware of any restitution in this matter?
No restitution, Your
Okay.
Honor.
Mr. Mowbray, Mr. Ogletree, you've had the opportunity to go through the pre-sentence report with Mr. Mowbray.
Yes, Your Honor.
All right. Any additions, deletions, or corrections to the pre-sentence report?
No, but there is comment. In it
All right.
says in regards to page 3, they're talking about under the diversion statute, MCL 769.4A. And at that time, at the plea, the prosecution and us were in agreement in terms of HIDA, and the court said that it would, as long as the probation report came back okay, that the court would seriously consider granting him HIDA status.
Yeah, I have a Killebrew to HIDA status. I don't know if the box is checked on 769-4A. I don't know, Mrs. L. That was a Killebrew.
Yes, Your Honor, we did agree to the Killebrew to HIDA. We would not be inclined to agree to the 7694A status in this case. However, we would be in agreement to HIDA.
All right. I have the Killebrew agreement as to HIDA. I don't know if that box was intentionally checked or not.
My thought is, since this is a domestic violence charge, it
The
was probably.
PSI says HIDA.
What is the recommendation?
The X 769, right?
That's where I got it from. Yeah, I go off.
All right. I think the PSI, the recommendation is for. Oh, has he had a prior HIDA? He has been on probation in the past and was successful with the term. Other than the one conviction in which he received HIDA status, his criminal history is clear. I think he's had HIDA in the past.
Yes, Your Honor, he has had HIDA once before, back in 2022, according to our records.
All right. So, Mr. Ogletree, there seems to be concern whether he can receive HIDA twice by the probation department. Did you want to meet with the assistant prosecutor to discuss, because that may be an issue here, whether I can Killebrew to HIDA status if he's already had HIDA?
I've been on other cases where they've granted HIDA before, but I'm willing to talk to the prosecutor. But I've been on cases where people have received HIDA more than once.
They may receive HIDA more than once, but I don't know if I'm willing to give HIDA more than once.
Okay.
Yeah. Ms. Izell, did you want to speak with Mr. Ogletree concerning the sentencing agreement? Or we can adjourn the sentencing to see if you may want to get Mr. Neves involved, because he indicates that previously he's had HIDA and then he recommends 769-4A.
Yes, Your Honor, at this time, I would ask for a brief adjournment so we could discuss this a little bit further with not only Mr. Neves, but with Mr. Ogletree and potentially some superiors in my office to make sure we have a good understanding of how we should be proceeding here.
All right. So, Mr. Ogletree, the Killebrew agreement was to HYT status. I don't know if I'm willing to follow that agreement, but I will let Mrs. L meet with some superiors to see if that's still an actuality. And if it is, then we can come back for sentencing. In the meantime, you may want to contact Mr. Neves, because I have a recommendation for 769-4A, but I have a previous recommendation that he received HYT status. So that might be an issue. I don't know. I'm pretty much guessing on some level. But if we can adjourn the sentencing for a new date, that might be able to clear up the issue. So, Mr. Ogletree, that's what the prosecutor's suggesting. I'll wait to hear from you.
That's reasonable, but I would like to know if I can inquire with the court if the prosecution does their due diligence as they've done before and talk to additional superiors. If they come back saying still in agreement to HIDA status, would the court still would be willing to still possibly grant HIDA status at that point?
Possibly. I'd possibly follow the Killebrew agreement if everybody knows, and And Mr. Neves also makes it a part of the report because it's not in the report. So I don't know if it's a previous HIDA that's keeping it or if it's a mistake, a checkbox, because Nathaniel tends to be, I know Mr. Neves, and so this could be a mistake. I don't know what it is, but it's worthy to you to get involved and find out if this is a mistake or if it's done intentionally and what we can and can't do. Right now it's a Kilberta HIDA status. If the prosecutor comes to me and says that's still good, then Mr. Mowbray, I'm most likely to indicate after Mr. Neves indicates that what was his intentions, I would follow that agreement.
All right, thank you, Your Honor.
All right. So let's do an adjournment for when we can, and then Mr. Ogletree, we should probably check your schedule, so we'll get a date, and then we'll get a date, and then you can tell us if that works with your schedule.
Okay.
August 5th at 1:30.
Is it possible to do on August the 4th?
August the 4th is a Monday, which is a city day. So it would have to be a Tuesday, which would be a statute day.
How about August the 12th, the following Tuesday?
August, we can do we might be able to do August the 12th, which is the following Tuesday. At the similar time of 1:30?
Yes.
All right. Let's set it for August the 12th. August the 12th at 1:30 for adjourned sentencing. And so we now know the issue. This will give everybody a chance to revisit this issue. So Mr. Mowbray, we'll see you on August 12th at 1:30 for the adjourned sentencing. And I think this is serious enough so that we have to clear it up before we go forward with the sentencing. Anything else for the record in 25-00786, Mrs. L?
Not for people.
Mr. Ogletree, do you have any questions of the court?
No.
All right, you should be all set. Thank you for your appearance today. Thank you, Mr. Mowbray.
Judge Flores,
Yes.
I apologize for interrupting, but I have another hearing at 3 p.m. in Eaton County, so I was wondering if you could call the matter against Miss Reagan.
Miss Reagan. Okay, Miss Osmond, that's LG Lansing.
Yes, Your Honor.
And is there Serenity Reagan here?
She's on Zoom, Judge.
All right. All right, let me pull that up and we'll see if we can call that case. But I've got to because if I remember correctly, was that a motion, Ms. Osborne?
Yes, Your Honor. It's a motion to reorder the writ of eviction.
Right. All right. Let me pull that up and we can call that case.
Thank you so much. I appreciate it.
It's the case is online, so I'm pulling it up electronically.
Okay.
That's why it's taken some.
I can give you the case number if that would be helpful.
No, we've got it, and I just gotta populate, just waiting for technology.
Not a problem.
All right, so we're on the record in docket 24-08761. This is that is LG Lansing LLC versus Serenity. Is it Reagan or is it Reagan, ma'am?
It's Reagan, yes, Your Honor.
Okay, thank you. Appearances for the record, Ms. Osborne.
Yes, Your Honor. Victoria Osborne for the plaintiff, LG Lansing.
All right. And ma'am, you are Serenity Reagan, is that correct?
Yes, I am, Your Honor.
All right. This is the time set for a motion in the matter. And so we adjourned as perfect service on the motion on July 15th. I believe that that service has been perfected, and we do have a motion. And I did read that motion this morning. Ms. Osborne, did you want to meet with Ms. Reagan concerning this motion, or did you just want to go forward?
I just want to go forward, Your Honor.
All right, you may. I did read it, but you go ahead and make a record, Ms. Osborne.
Okay, thank you, Your Honor. On or about January 27th of 2025, the parties entered into a conditional dismissal, which allowed Ms. Reagan to avoid a judgment of possession by making monthly payments to the plaintiff. I was informed by the property manager that she failed to make the terms of the conditional dismissal on or around April 1st of 2025 by making the monthly payment that she was supposed to. So the plaintiff ordered a writ of eviction, which was granted by this court. And in the interim, the property manager contacted me and indicated that the payment had been made and she was willing to not execute the writ of eviction. So the writ of eviction was never executed. Subsequently, Ms. Reagan has defaulted numerous times on the same conditional dismissal by failing to make her monthly installment payments of $300 that were due on April 15th, May 15th, June 15th, and July 15th. And additionally, she has failed to make her monthly rent payments for the months of April, May, June, and July. Because MCR 4.201 M4B limits enforcement of a writ of eviction by 56 days of issuance, we are asking this court to reissue the writ of eviction so we can execute it.
Thank you. Ms. Reagan, you understand the nature of the motion. Do you have any response?
Yes, I was just seeing if I was able to talk to her privately about just some I'm not too sure like how I go about this, but there's just like a couple of things that I'd like to talk about. I don't know if I talk about them with her or with the court directly pertaining.
Most likely you talk to the property manager who's employing Ms. Osborne.
Yes, correct. I did talk to them about the issues and they never got resolved. That's why I was just curious like who I would talk to, about those situations, because I have like emails and like I've called them multiple times about like issues pertaining to my apartment like itself, and there's been nobody just like that reaches back out to me or like comes to the property that fixes like the issues. So I was just curious if I was able to just go in a private room and just talk to her about that. I'm not too sure how this works.
Your Honor, this is a moot point. Her time to talk to me and disclose those issues were when she signed the conditional dismissal.
Yeah, most of this is based on the conditional dismissal that you signed, and I know we go through that in the courtroom explaining the conditional dismissal. And if you're not represented by counsel, you have 3 days from the date to indicate that. And actually, you've had more time than that because this is actually an eviction that was never signed. And that's what Ms. Osborne's indicating, that after 56 days, she has to come back and kind of reopen the case. That's the nature of the motion. Is that correct, Ms. Osborne?
Yes, Your Honor.
All right. So, Ms. Reagan, do you have anything in regards to reopening the eviction after 56 days?
I'm sorry, I don't understand your question, Your Honor.
The motion is to reopen the eviction after 56 days because there was not an eviction done before 56 days because the writ was pulled back to execute an eviction because I'm assuming because the client felt complied with at the time. Is that correct, Ms. Osborne?
Yes, Your Honor. She had made her monthly payment and the property manager was essentially giving her the benefit of the doubt or a second chance.
All right. So Ms. Reagan, do you have any response to the property manager through Ms. Osborne requesting that after 56 days they're allowed to request from the court to order an eviction because one was not filed before.
Yeah, yes, there's two separate property managers. The one before, her name was Bessie, and when I had spoken to her, I was under the impression that the issue that I was having with the property at the time would be resolved, and they ended up switching property managers. And so I had let them know of all of the same issues that I was having. Like there was infestation of mice throughout the whole, like apartment complex. And I didn't realize it right until after Bessie had.
Was that done after the conditional dismissal?
Yes, that's when I realized that there
All
was
right.
an infestation of mice. Like I said, I have, like picture proof. I have, emails of me emailing the property manager. My air conditioner has been broke like this whole
Yeah,
time.
this isn't the time to litigate your case.
Okay,
You've already
okay.
requested a
I'm
conditional dismissal.
okay. I'm
All
sorry.
right. So Ms. Osborne, I'm going to grant the motion to reopen the case after 56 days and order an eviction. You'll follow that up with an order, ma'am?
Yes, Your Honor, I will file an application for a writ of eviction.
All right. And then, Ms. Reagan, I would talk to your property manager. That's the employer of Ms. Osborne. That's employing. But at this point in time, it's obviously problematic. It's come down to whether you want to live there or not. And they're reopening the case after the eviction's been processed, after the 56 days. That was the nature of this motion. It's really a technical motion.
Thank you, Your Honor.
So you should probably talk to your property manager, Ms. Reagan.
Okay, thank you.
All right. All right. We will await to sign the order. Ms. Osborne, thank you for your appearance today.
Thank you. Have a good day.
You too. You're all set, Ms. Reagan.
Thank you.
I'm going to say, right? We'll put in the notes later on that. All right, and we have Miss Post, Mrs. L.
Yes, Your Honor. And there is going to be restitution in that file. Would you like a pink sheet for that?
Yeah, I have restitution at $207.01.
Correct.
And I do have a pink sheet in the file.
Perfect. It's already one in there.
And that the victim's name of restitution is Tiffany Jones.
Correct.
Okay. All right. And Mr. Annette, this is your case.
Sure.
All right. And Miss Post, you can come up here.
I'll zoom.
Oh, is she on the Zoom? There she is. All right. All right. So we're on the record. This is a plea of no contest to the docket large. Is that correct?
It is.
All right. So we're on the record in docket 2500821. That is People of the State of Michigan versus Ashley Sarah Post. Appearances for the record, Mrs. L.
Thank you, Your Honor. Gabrielle Ezel, Assistant Prosecutor for the people.
Mr. Annette.
George Annette, APD on behalf of my client is appearing via Zoom today.
And ma'am, you are Ashley Sarah Post, is that correct?
That's correct.
All right. And did you seek leave to appear via Zoom at this hearing?
Sir,
I just don't know.
yeah, so she informed, I asked her about that. She, I think, informed me that she does not remember getting a notice in the first place. I think I'm the one who told her about today's court date, if I'm not mistaken. She said she doesn't remember getting a notice.
All right, so you found out to be here through Mr. Annette, your lawyer, is that correct?
I was reminded of it. I remember in our last hearing when we had last been in the courtroom that we had decided on this date. And
All right.
other than that,
So
I
it's set for July 15th. I do most sentences live in person, but I'm this sentencing dog at large, I think we can do by Zoom. Is that do you have any objection to that, Mrs. L? All right.
Your Honor.
All right. With that understanding, ma'am, you are Ashley C. Sarah Post, is that correct?
That is correct.
All right. Restitution's been indicated and been filed in a pink sheet. Mr. Ned, have you had the opportunity to go through the pre-sentence report with your client?
Went over it today, Your Honor. I believe, at least looking at my notes, I think today's purpose was understanding what if there was any remaining of restitution.
Okay.
I'm not sure. I think this was the reason this was set for today was the purpose of restitution.
I have referred to probation 48-hour sentencing date today. That's what I have for today.
Okay, I think I was under the impression that this was for the purposes of restitution only, but nevertheless, there is PSI. I did review. I don't believe there's any recommendation. I believe it's just the restitution amount, if I'm not mistaken.
All right. So, Ms. Post, you've had the opportunity to see and go through the pre-sentence report. Is that a fair statement?
Yes.
All right. Without any additions, deletions, or corrections to note of, Mr. Ned, would you like to be heard on allocution?
Yes, Your Honor. Based on the circumstances in this case, I suppose is apologetic for what happened. When we discussed the veterinary bill today, I inquired into some things that she had no problem in paying. She's open to paying restitution. And she does not want to contest anything. She's sorry for her actions. This should never happen again.
All right. Anything towards if I remember, let me see. It was a no contest with no killabrew. Anything towards allocution, Mrs. L?
No, Your Honor, we would leave this to your discretion. We do believe that the restitution and potentially fines and costs would be good for this
All right.
case.
And I do believe the probation agent would be Jody Bayless, who wrote the report. All right, Ms. Post, is there anything you'd like to say to the court before the court passes sentence?
Nope, nothing for me.
All right. All right, this is for a guilty plea, no contest on May 20th, 2025. It is ordered that the defendant spend 0 days in jail. Credits given, I don't have 0 days previously served. This is indicated by the probation by the probation department that this be roughly fines and costs and restitution only. That there was no risk to the community. So I'll follow the restitution to Tiffany Jones would be $207.01. Crime victims' rights fee of $75, state minimum court cost fee of $100, and then fines and costs are $200 for a grand total of $857. Is that right? That doesn't sound right. Let's go again. That sounds right. $532.01. And that can be referred to collections for the amount indicated. So, Ms. Post, you should contact the City of Lansing Collection Department to set up whatever plan in order to provide to them. That restitution would come off the top. So that would, the $207 would come off the top, and then they'd go to fines and costs and crime victims' rights. But that will be referred to collections per the amount that's owed. So you should probably contact the City of Lansing. Yeah, you have to come in and do, the person to see on the 6th floor for the City of Lansing is probably Marquita. You'll probably have to come in and make sure you've set up a payment plan. So that'll be referred to collections, and you should probably do that in the next couple days, all right?
All right, I'll try to get down there tomorrow.
All right, so we'll say this is Wednesday, and I'm going to refer to collections, or Tuesday, and we'll refer to collections on this matter. And then they'll be expecting you at the collections department on the $532 total. Anything else for the record in 2500821, Mrs. L?
Not for the people.
Mr. Ned.
No, Your Honor. Ms. Post, I'm gonna give you a call here in a minute.
So Ms. Post, they'll be expecting you at the collections department. That'd be great if you could come tomorrow, okay, ma'am?
Okay, sounds good.
Okay, you should be all set. Thank you for your appearance today.
Thank you.
Welcome back.
All right, so we'll be calling Credit Acceptance Corp. and Alice Woods next. That's docket 1302021. After I get the, we're having some technological issues, so I want to make sure we get the case pulled up. All right, do we have a representative of Credit Acceptance Corp?
Yes, Your Honor. Ryan Malali, Pete 88457, representing Credit Acceptance.
All right, is there an Alice Woods? All right, Ms. Woods, you can have a seat there. So we're on the record in docket 1302021. That's Credit Acceptance Corp. versus Alice Woods. Appearance for the record, Mr. Malone.
Ryan Malali, Pete 88457, representing Credit Acceptance.
Thank you. And ma'am, you are Alice K. Woods, is that correct? All right, this is I have a motion for installments. There was a fail to appear previously, and then defendant one showed up late for hearing, and you were sent to the civil department, is that correct?
Yes, I was a little late coming to work last time.
All right, have you had the opportunity to speak with Mr. Mullally concerning this matter at all?
No, I haven't.
Would you like that?
Yes.
Mr. Mullally, would you be amenable to meeting with Ms. Woods before your motion?
Yes, I would.
All right, we can put it on an iPad and give you some privacy, so you can speak to Mr. Mullally. I'll put you in a breakout room, and then we can come back and put it on the record.
Okay.
All right.
Thank you so much.
So, Mr. Mullally, I'm going to have you placed in, assuming anything works, which is a big assumption.
Okay, that sounds good. And I'm also here on one other case, LVNV Funny versus Kathy Smith. So
Okay, all right.
She's here.
Let me
too.
circle that so I know where you are.
Yeah, exactly. Thanks.
And then let me see if I can put you in a breakout room. I don't think did we? So give me 1 second. We'll put you in a breakout room because none of the breakout rooms are working right now.
Okay.
Hello. Can you hear me?
I can't. We can't. We're gonna put you in a breakout room. We just gotta find the breakout rooms.
You don't know I'm in the breakout room.
Do you want me to co-host?
Yes. Breakout rooms.
Okay.
All right. And then we may need somebody here for breakout rooms if there's any.
I'm right here.
Yeah, I mean, we'll need somebody.
Oh.
other than me? All right, so we're on the record in 24-05947. Is there a representative from Triad Financial Services?
Yes, Your Honor, Attorney Elizabeth Ellison.
All right, and is there a Roquel Bertley here?
There's nobody in the hallway.
All right. All right, let's call that case. That's a 2:30 case, and it's 3 o'clock. All right, so we're on the record in 24-05947. That's Triad Financial Services versus Roquel Bertley. Appearances for the record, Ms. Ellison.
Good afternoon, Your Honor, Attorney Elizabeth Ellison, P82098 for the plaintiff.
All right. This is the time set for a motion to reopen. I do not see Raquel Bertley in the Zoom courtroom or the physical courtroom, and nobody's in the hallway. It would appear that Ms. Bertley has failed to appear for the motion. Ms. Ellison, how would you like to proceed?
Your Honor, this is our motion to open following bankruptcy dismissal, as well as for the judgment order, immediate order of default judgment. I wish to proceed on my reopening and the default judgment. This is a claim and delivery action with the request for a money judgment, Your Honor. This case was filed August the 15th of 2024. She was personally served September 30th of 2024. She was defaulted on December the 2nd, served a copy of that default request on December the 6th. She filed bankruptcy on December the 19th of 2024. That bankruptcy was dismissed and terminated with no resolution on April the 1st of 2025. We have filed this motion and served her notice, as well as the notice of hearing, on June the 11th, 2025. She remains in the home, Your Honor. The money judgment we are requesting is the principal and interest on the manufactured house is $11,968.75. Pursuant to 12C of the contract, actual attorney's fees for foreclosure are to be borne by the defendant. That is $1,726.65. We're asking for a money judgment in the amount of $13,695.40. Your Honor, she will have 21 days, if you grant the motion, to become current. If she does become current, then she can remain in the home. If not, we will provide the court with the order of the writ of seizure of the property, Your Honor, and then ask the bailiff to give my client back the home, and they will sell it and apply it to the money judgment.
And that'd be after the 21 days. Is that correct?
That is correct, Your Honor. We wait the appeal period.
All right. So for purposes of default, the tenant and we do have service on the case, and Ms. Bertley is not here. I will grant the default and the orders to follow concerning the motion.
Thank you, Your Honor. I will get that submitted to my file.
All right.
Have a good day.
All right. Anything else for the record in 24-05947, Ms. Ellison?
Not from myself, Your Honor. Thank you.
All right. You're all set. Thank you for your appearance today.
You as well. Thank you.
All right, is there a representative of Sun Home Services?
Your Honor, good afternoon. Christopher Sasson appearing on behalf of Sun Home Services.
Perfect. And is there a Monique Brown here? All right, Ms. Brown, you can come forward. All right. So we're on the record in docket 24-08646. Mr. Sasson, your appearance for the record.
Your Honor, good afternoon. Christopher Sosson, spelled Sossong, P59383, appearing on behalf of the plaintiff.
All right, and ma'am, you are Monique Brown?
Yes.
And is Clarence Brown with you? I only have Monique Brown on this motion.
Right.
That's correct, Your Honor.
All right. So this is a time set for I have a motion for summary disposition. We were previously here. So this was previously, we're here on June 17th. I granted a motion to set aside summary disposition. D2 did not have proper notification. So we had a new hearing date set on July 15th at 2:30, which is today's date. Mr. Sosson, did you want the opportunity to speak with Ms. Brown in a breakout room, or did you want to go forward on your motion for summary disposition?
No, Your Honor. I'd be more than happy to speak with Miss Brown in a breakout room before, to see if we could resolve this this pending motion. If not, we can certainly come back.
All right, Ms. Brown, would you be amenable to meeting with Mr. Sosson? No. Okay. All right. So, Mr. Sosson, I will hear your motion for summary disposition at this time.
Thank you, Your Honor. First, I would note for the record, this motion for summary disposition as to the co-defendant Monique Brown is dated April 29th and was filed on or after April 29th, 2025. Said motion for summary disposition, along with the brief and support, attached exhibits, were in fact served on the defendant according to the proof of service on April 30th of 2025. They were served to the defendant at her current address, 5643 Schaefer Road, Lansing, Michigan, 48911. To date, I would note for the record, this office has not received any written response from Ms. Brown to the motion for summary disposition, nor has this office received any affidavit in response to the motion, any affidavit opposing the motion from Ms. Brown, nor any other documentary evidence that would oppose plaintiff's motion. This is a motion that's brought pursuant to MCR 2.116 C9, C10, and I1. And for the reasons as set forth in both the motion and attached brief and support, Your Honor, plaintiff is seeking judgment against Ms. Brown for the complaint damage amount of $2,573.55, in addition to taxable costs and the statutory attorney fee. As set forth in our motion, this is a claim. These are claims that were brought by plaintiff, claims of breach of contract, account stated, and unjust enrichment for the recovery of a balance owing as a result of a tenancy that the defendant entered into with plaintiff as set forth in attached exhibit number 1. As referenced in attached exhibit number 1, the defendant had entered into a manufactured home lease agreement with the plaintiff for a fixed period of 12 months, commencing on October 1 of 2021 and terminating on September 10 of 2022. The lease agreement, the manufactured home lease agreement that the defendant had entered into with the plaintiff, is attached as in exhibit number 1 in support of plaintiff's motion. That agreement set forth in attached exhibit number 1 is signed by the defendant. The defendant also had entered into a site lease agreement with the plaintiff as well. That site lease agreement is contained in attached exhibit number 2. And the defendant entered into that as well for a corresponding period of time from October 1st, 2021 to September, looks like 30th of 2022, to correspond with the exact time period as set forth in the manufactured home lease agreement. Defendant entered into these agreements and agreed to be bound by the terms and conditions thereof. And at some point during the defendant's lease agreement with the plaintiff was for a 12-month period. It commenced on October 1, 2021, and it terminated on September 30th, 2022, and defendants had agreed to pay $605 on the first day of each month. At the end of the 12-month lease period, the fixed lease term, defendants had remained in possession of the manufactured home and leased site on a month-to-month tenancy, which continued until the defendants vacated the home and the site on or about November 1 of 2023, without providing the required written notice of their intent to terminate the tenancy. At the time that the defendants at the time the defendants vacated, they had made rental payments through September 30th of 2023, but failed to pay rent on October 1 of 2023. Also attached in support of plaintiff's motion for summary disposition is plaintiff's resident ledger, which reflects from the inception of the lease through the conclusion of the lease and the conclusion of the tenancy, all charges, payments, credits applicable to this particular tenancy with Ms. Brown. As plaintiff's resident ledger supports, the last payment made by the defendant, Ms. Brown, was on September 7th, 2023, in the amount of $1,395.16. The defendant failed to remit or pay October's rent as set forth in the motion. And so subsequently, after possession, the plaintiffs had also charged rent for November of 2023 due to the defendant's failure to provide the requisite written 30-day notice of intent to terminate. And so after possession was returned, the plaintiff did a walkthrough where additional damages to the property were discovered that required repair. And as a result, due to the damages, the plaintiff had charged the defendants $1,683 for repairs to the property that was returned. Subsequently, a final statement of security deposit account against the $500 security deposit that was provided by the defendant at the outset of the lease. A final statement of security deposit account was in fact provided to the defendant subsequent to the defendant returning possession of the property to plaintiff. And that final statement of security deposit account is included and attached in exhibit number 4 in support of plaintiff's motion for summary disposition. And I would note as well that plaintiff, after it did its walkthrough, revised the damages. Those damages were in turn revised down to $1,240, which is reflected as a revised damage credit in the final statement of security deposit account. So the total damage amount was $1,240. In addition to the other utility charges, late charges, and unpaid rent, the plaintiff had sent the defendant the final statement of security deposit account indicating that the defendant owed plaintiff $2,573.55 as the unpaid balance upon the conclusion of the tenancy. The defendants breached the terms of their lease agreement. This defendant breached the terms of the lease agreement by failing to pay the amount due to plaintiff. Subsequently, The plaintiff commenced this cause of action to recover the unpaid balance owing to it. Defendant was served with the summons in the complaint. And Your Honor, the defendant did file an answer to the complaint. The defendant's answer is simply a one-page answer, and it fails to comply with Court Rule MCR 2.111 C through D by clearly responding to each paragraph in plaintiff's complaint. As a result, it is plaintiff's position that because the defendant's answer fails to comply with Court Rule MCR 2.111 C through D by answering each and every allegation as set forth in plaintiff's complaint, it is plaintiff's position that each allegation in plaintiff's complaint is therefore deemed admitted pursuant to MCR 2.111 E1.
Are you referring to the response letter of January 22nd, 2025?
Yes, Your Honor, that is correct.
Okay.
Additionally, I would note that in the response letter dated January 22nd, 2025, as that is treated as the defendant's answer to the complaint, the defendant doesn't outright dispute owing the charges. The defendant just in her answer requests that she be provided with a final bill for the individual charges, claims she didn't receive a copy of the final statement, but the defendant doesn't outright dispute owing that amount. So I make that point because the defendant, even in her response letter, doesn't actually dispute owing the complaint damage amount being sought by plaintiff. Additionally, at the time the defendant filed this as her answer to the complaint, the defendant was also required to raise, if she had any affirmative or legal defenses to plaintiff's claim, pursuant to MCR 2.111 F2 through 3. The defendant, along with her answer, did not file, raise, or assert any affirmative defenses, any legal defenses whatsoever to plaintiff's claim, which the defendant was required to do if she had any when she filed her answer to the complaint, particularly those affirmative defenses that must be filed along with the answer as the first response of pleading. Otherwise, they be waived pursuant to MCR 2.111 F2 through 3. Again, I would note the defendant has not filed, raised, or asserted any affirmative defense whatsoever. So plaintiff subsequently, Your Honor, filed this motion for summary disposition, given that there's no genuine issue of material fact for trial, and because the defendant has not filed, raised, or asserted any valid affirmative defense to plaintiff's claim. I would also note as well, for the record, that the court had granted discovery during the course of this pending litigation, and discovery requests were in fact served on the defendant. And those discovery requests, Your Honor, were served on the defendant on March 6 of 2025. Those discovery requests included plaintiff's requests for admissions. The defendant failed to respond to any of plaintiff's discovery requests. The interrogatories, the request for production of documents, and the request for admissions. Specifically, as it relates to the request for admissions, it is plaintiff's position that, based upon court rule MCR 2.312B1, that each request is each matter as to which a request for admission was made is a deemed admitted fact because the defendant has failed to respond to plaintiff's request for admissions. So, in summation, Your Honor, it is plaintiff's position that all of the attached documentary evidence to plaintiff's motion for summary disposition, in addition to the admissions of fact, well support plaintiff's motion for summary disposition, that there remains no genuine issue of material fact for trial, and that entry of judgment as a matter of law is appropriate and warranted. Additionally, the defendant has not raised any affirmative defense to plaintiff's claims. Finally, the defendant was required pursuant to MCR 2.116G4. The defendant is required when a motion is based upon subrule MCR 2.116C10, a defendant is required to file a written response in opposition to the motion or to oppose the motion by affidavit or is otherwise provided with documentary evidence. And the defendant in this case has not filed any written response. She's not filed any affidavit in opposition to the motion, nor she proffered any documentary evidence that would oppose the motion. She can't rest merely on her answer that she filed, which answer is dated January 22nd, 2025. She can't rest merely on her answer as filed, but must properly oppose plaintiff's motion. So in summation, Your Honor, again, for all the reasons that I've just argued on the record here today, and for all the reasons as set forth and thoroughly discussed as well in both the motion and the attached brief and support, it is plaintiff's position, again, that this motion is proper or warranted, and that entry of judgment as a matter of law in this case is proper and warranted against the defendant. Respectfully, the plaintiff would request that the court grant its motion, this motion against the defendant, and enter a judgment for the relief requested. Thank you very much.
Thank you. And my understanding, Mr. Sung, is we did have a pretrial on this on March 3rd. Is that correct? And we set the cutoff date for discovery on June 2nd.
May I just research my notes, Your Honor, to
You can. I have on the 248646 pretrial conference was held on March 3rd. Ms. Brown was here. I think Sun Homes had a different representative, and we set discovery cutoff date at June 2nd with the understanding that we were going to hold back on a motion for summary disposition until after discovery.
Just one moment, Your Honor.
I signed
Yes, Your
via
Honor,
Zoom.
That's what my
For Ms.
records reflect.
Okay. All right. All right. Ms. Brown, response concerning the motion for summary disposition.
Okay, so first off, Your Honor, everything that he was saying, I did not understand. I am unaware, I was unaware that I was supposed to address or answer any of these questions in all of these papers that I was receiving. I've received numerous packets of paper, he is correct. But looking through the papers, all I was seeing was the same papers. So I didn't realize that I was supposed to go line by line, reading these and answering these questions. I did not know.
What did you answer, ma'am?
Only thing I did was send in the letter
dated January.
In January.
All right.
That's all I did.
And that's the only thing that
Right, that's
the plaintiffs
the only thing I sent
received.
in because
Even
I didn't realize that I was supposed to answer these questions.
all right, even after the pretrial of March 3rd.
Well, when I came down here and we spoke the last time I was here for the motion, and I didn't speak to this gentleman, I was in a breakout room with another gentleman. He never explained any of this to me, and I assume, I guess not, because he was against me.
Right.
Only thing he told me, good luck. He didn't say, you know, you didn't answer this, you didn't do this, you didn't do that. You know, what is your stance on this? Or that's what I was thinking we were going to be discussing. He said, are you going to pay us or not? And I was like, I don't feel that I owe you this money. He said, well, good luck. And that was it.
Right.
So I didn't realize that I was supposed to answer all of these questions. So he's correct. I didn't, because I didn't know. Had I known, I would have.
Any other response to Mr. Sassang's motion?
Far as all of the things that he was saying, yes, we were in the mobile home for 2 years. Our lease was up at the end of September because we signed on October 1st. So when I talked to the lady in the office in September, I told her we was going to be moving. there was no need for me to pay rent in October. And we were gone by October 1st.
When was the lease up, man?
The lease was up at the end of September, September 30th.
And then you were on a month, your indication
We were
was
in a month, we were, I guess, month to month. I didn't realize it, but we were gone by then. I have a letter stating from the lady that I hired to clean the trailer. We were
so you
already,
did not want to talk to Mr. Sung about any of it?
because I didn't, like I said, the last man I talked to was so rude. I didn't feel like, what was I gonna say to this man? What was he gonna say to me? The same thing. So it didn't make sense for me to talk to him in my mind because of the last response that I received from the last gentleman. Now, if the other guy had been talking like this man is and kind of explaining things to me a little bit differently, then I wouldn't have a problem speaking with him. And then I would know exactly what I was supposed to be doing. But if don't nobody explain it to me, how would I know?
I don't know, but we've got a problem now because
I
we filed a
understand.
motion and with a lot of law behind it. And what a motion for summary disposition is as a matter of law, I've proven there's no facts to be argued around about this.
Okay.
And then you've indicated that somewhat of what he said is true based on your non-admitting because you didn't know.
Right.
Any other response? Any other argument, Ms. Brown?
As far as the charges, that's one of the things that I have discrepancies about is the charges that they were charging me. That I understand that they charged me $1,600, then they broke it down to $1,200, but it was still it was a ridiculous amount of money. They're trying to charge me $500 for blinds.
Right.
And $900 for painting of the trailer.
And we're not going to read that. We're going to have the opportunity. We had a pretrial on this. We had a pretrial and discovery issued March 3rd.
Right. I know I was on a Zoom call, but
you allow signature via Zoom on March 3rd. All right. All right. Is
that when I was supposed to talk about the charges?
I don't know. I can't represent you on this.
No. I'm just asking the question.
I'm uncertain. I'm uncertain.
Okay.
Mr. Sung, anything else concerning your motion?
No, thank you, Your Honor.
All right. Well, there's a disconnect here, but Ms. Brown, this probably should have started at least prior to the pretrial, if not when you answered with that letter. And it probably should have been, you probably should have consulted a lawyer at that time, okay, depending, okay? But I'm under duty to follow the law, and Mr. Sung has put it in a motion format, and I'm going to grant, Mr. Sung, I'm granting your motion for summary disposition. You will submit an order to follow in regards to breaking up so that Ms. Brown understands the classification concerning the charges. You'll break it down for me to sign. Is that correct?
Yes, Your Honor, I will.
All right. All right. With that understanding, I'm granting the motion for summary disposition. I will sign that when it's presented to me. We should be all set today. All right. You're all done, Ms. Brown.
Thank you.
Thank you.
Thank you very much, Your Honor. Have a good
Thank
day.
you, Mr. Sung. I'll worry about that later. All right. So, Mr. Mullally, were you here with Miss Woods?
Yes, I'm here with Miss Woods. I also have another case, but I'm ready to go on Miss Woods whenever you're ready.
All right, let's bring back Miss Woods is here. All right, so we're back on the record in 13-02021. That's credit acceptance quote versus Alice Woods. And Mr. Mullally, you indicated you had the opportunity to speak to Ms. Woods in a breakout room prior to the objection for installments. What, if anything, came out of that meeting?
The defendant and I have both agreed to file a stipulated order for installment payments. I can read the terms into the record if you would like.
Sure.
Okay. The defendant must pay the judgment balance in installments of $160 per month starting on August 19th, 2025, and continuing on the 19th of each month thereafter until the balance is paid in full. That the writ for periodic payments issued on January 23rd of 2025 is suspended, and the garnishee is ordered to discontinue withholding payments. And that if the defendant fails to make the above payments, the plaintiff shall file an affidavit of noncompliance where the stipulation and payment order will be set aside and the periodic garnishment will be reinstated without further court hearings.
All right, and Miss Woods is gonna, is she gonna authorize you to sign her name to the document, or are you gonna have it reviewed, or how's that gonna work?
She did orally agree to have me sign her name to the order in the breakout room. If we could get that on the record, that'd be great.
All right, so Ms. Woods, you've given authorization. First of all, is anything that Mr. Mullally indicated, is that in terms of what you agreed to?
Yes, it is.
All
Your
right,
Honor.
and you're giving authority for Mr. Mullally to sign that document on your behalf to advance to the court in order to expedite the hearing?
Yes, Your Honor.
All right, with that understanding, I will await to sign the order after consent of both parties concerning the order for installment payments as indicated for the record. And that'll be filed through the e-file system, Mr. Mullally?
Yes.
All right. Anything else for the record in 13-02021, Mr. Mullally?
No, I'm all set on this one, Your Honor.
All right, Ms. Woods, do you have any questions of me?
No.
You should be all set. Thank you for your
Thank you
appearance
so
today.
much. So do I get like a paper to take to my employer?
You'll get a copy of the signed order.
Okay.
And that you should take that wherever you need to take that.
Okay.
Okay. You might be able to get an unsigned order from from the owners of the property. But you'll definitely get an order sent to you to sign.
Okay, but not today.
Not today.
Okay. Thanks so much,
You're
guys.
welcome.
I appreciate it. Thanks so much, Mr. Martin. I appreciate it.
All right, and then we'll go on the record. You have Miss Smith, and she's here.
Yeah. Is there a way
Okay.
for me to go in the breakout room on this one too?
Yes, there is. I can't do it, but I can find somebody who can do it. So we're on the record in docket 25-02411. That is LVNV funding versus Kathy Smith. Appearances for the record, Mr. Mullally.
Ryan Mullally, P88457, representing LVNV funding in this matter.
All right, and ma'am, you are Kathy Smith, is that correct?
Yes.
I have this time and hearing set for motion for summary disposition. Mr. Mullally has indicated that he would like to speak to you in a breakout room prior to the motion, Ms. Smith. Would you be amenable to speaking with Mr. Mullally in a breakout room?
Yes.
All right, I'm going to have Mr. Mullally and Ms. Smith placed in a breakout room. Megan, I'll have you do that because I can't find the breakout rooms right now for whatever reason, and
They're gone.
they are gone for whatever reason, and we'll come back and put it on the record. All right, and then Mr. Dowrick.
Yes.
I don't have anything working here, so I'm just. All right, so Mr. Dowrick, you're here on 25-02425. Is that correct?
Yes, sir.
And that's with Miss Shrita Deering. All right. So we're on the record in docket 25-02425. Appearances for the parties, Mr. Dowrick.
Todd Dowrick.
And ma'am, you are Shrita Deering, is that correct? Miss Deering, Your video just came on. You are Sharita Deering. You'll have to unmute.
Correct.
Okay. This is the time set for a motion to set aside judgment. It's my understanding, and correct me if I'm wrong, you signed a consent judgment with Mr. Dowrick, and now you've requested that we set that consent judgment aside. Is that correct, Ms. Deering?
Correct.
All right. Mr. Dowrick, any objection to setting aside the judgment from the plaintiff?
The judgment is paid now. It's paid in full. Some money is owed for the month of July, but the June 25th, 2025 judgment is paid.
Did you want to talk to Ms. Deering in a breakout room just so you can converse about what's happened since this has occurred, and then we can come back and place it on the record?
That would be great.
Ms. Deering, would you be amenable to meeting with Mr. Dowrick in a breakout room?
Yes.
All right. So I'm going to have Mr. Dowrick and Ms. Deering placed in a breakout room. Yeah, I can't see. So. All right.
She's impatient right here.
Or fast.
Whatever.
Where did my breakout rooms go? Let's go on Mr. Smith's. I think this is Mr. Smith's cases. So let's go on LAFQ 1602842. That's LAFQ versus Don McCray. Appearances for the record, Mr. Smith.
For plaintiff LAFQ, Tim Smith, P 48259. Good afternoon, Your Honor.
All right. And is Don McCray in the courtroom? All right. If this was scheduled for 3 o'clock, it's now 3:40. And I do not see a Don McCray in the physical courtroom or the physical courtroom. There's nobody in the hallway. I would appear that Don McCray has failed to appear for the discovery proceeding. Mr. Smith, how would you like to proceed?
I'd like to file a motion to show cause, Your Honor, with the service to be effectuated via mailing to the address on the original subpoena where personal service was effected originally.
Okay. So, and I do have an actual file for this. So I'm going to indicate the defendant failed to appear for discovery. It was set for 3 o'clock and it's now 3:40. And there's a request for show cause, which is granted. And you'll follow that up with an order to that effect, Mr. Smith?
Correct, Your Honor.
All right. All right. So anything else for the record in 1602842, Mr. Smith?
Nothing for plaintiff. Thank you, Your Honor.
All right. Thank you. And then I think we have another 1800898. That is LAFQ versus Anthony Budd. Is there an Anthony Budd here? All right. So in the file of 1800898, LAFQ versus Anthony Budd, your appearance for the record, Mr. Smith.
For plaintiff LAFQ, Tim Smith, P 48259.
All right. This is the time set for a discovery hearing. It was set for 3 o'clock. It is now 3:42. It would appear the defendants failed to appear for the discovery hearing. I don't see Mr. Budd in the Zoom courtroom. There's nobody to that effect in the physical courtroom and nobody in the hallway. It would appear that the defendant failed to appear for the discovery hearing. Mr. Smith, how would you like to proceed?
In light of his failure to appear, we'd like to file a motion to show cause with service to be effectuated at the same address where service on today's subpoena was served.
All right, so the motion show cause is granted, and that'll be set. You'll follow that up with an order to that effect of Mr. Smith.
We will prepare and submit, Your Honor.
All right. All right, anything else for the record in 1800898, Mr. Smith?
Nothing, Your Honor. Thank you.
Okay, thank you. Thank you for your patience today.
You bet. Thanks.
All right, and then let's go back on the record in docket 2502411. I'm sorry, yeah, 2411. And that is Mr. Mullally or LVNV Funding versus Kathy Smith. And Mr. Mullally, did you have the opportunity to speak with Ms. Smith in a breakout room?
I did, Your Honor. Unfortunately, we've been unable to come to a resolution. So at this point, I'm just hoping to get a ruling on the motion for summary.
All right. And so did you want to proceed with your motion, Mr. Mullally?
Yes, I would, Your Honor. You know, I reviewed the defendant's answer and spoke with her in the breakout room. There doesn't appear to be any contesting it here whatsoever. The issue is financial hardship and she's unable to make payments. So there really is no genuine issue, a material fact, and there's no valid defenses raised by the defendant at this point.
The nature of the Ms. Smith of the motion is this is a legal motion that is filed in order to make a legal judgment. And what Mr. Mullally is saying is that it's not an if you should pay or can you pay. You're simply unable to pay.
No,
any response to that?
I told him that I could not pay $105, which is what he said. I told him that I have 2 other judgments and that I'm also paying the IRS at the present time, and that I couldn't pay $105, and that that's what he wanted me to pay. I set it up for 20 because I figured that would be able to, once I get one of the other judgments paid off, I could probably do 30, but I don't have it. I'm actually facing eviction right now trying to gather that. I had an accident around the time of the credit card, and it totaled my car, and I was, laid up, and that's what happened. And other than that, I have been paying that card on time. And then by the time I got back well, the card had already been sent to collection. So I just don't have $105 to pay that. That's what I told
Any
him.
other response to the motion, Ms. Smith?
That if the court could maybe a lower payment, maybe 30, 40, I just can't pay 105. And he's talking about garnishment. If I'm garnished, I'll lose my home. I'll be homeless because I'm going through eviction right now at the time.
Thank you. Any response, Mr. Mullally, on your motion for summary disposition?
Just that, the $20 a month is just not agreeable to my client, and I couldn't really get her to go up from there. And
I just said I could try for 30, maybe 40, but I can't do 105.
Right, Ms. Smith, I'm going to grant the motion for summary disposition based on Mr. Mullally's motion and your response for in regards to LVNV funding. You're going to have to prioritize or do what you can, but at this point in time, I simply do not see a legal issue. What I see is a payment issue or the inability to make the payments that are owed, and therefore the motion for summary disposition is granted, and you will follow that up with an order from LVN funding, Mr. Mullally. Is that correct?
That's correct. I can file that.
Can I talk to him again and see if maybe 75? I can try to do that.
You can contact the office, the property manager, or you can contact the office, but I can't place you in a breakout room without some consent. And that's not an option today.
Yeah.
What do you mean consent?
That means Mr. Mullally wants the hearing to be done based on his
Okay.
motion,
Okay.
and he can do that.
Okay.
All right. All right. So if you file, I will sign on presentation. Thank you for your appearance today, Mr. Mullally.
Yeah, and if I just say one more thing, that if defendant wants to set up a payment plan, she can still call in our office after this hearing date and try to get this resolved, but at
Right.
this
So
point.
Ms. Smith, that would be available as long as you call the office and set up some type of payment plan if it's acceptable, but that's not a part of this hearing.
Is there a number for me? Because there's nothing on this paperwork.
There's a number, I got it right here, call 586-558-9000. And you'll get an account representative over here.
And would that stop any type of garnishment? Because I don't want to be homeless.
I can't give you that. I don't know. I don't know the answer to that.
Okay.
All right. All right, Ms. Smith, thank you for your appearance today. You should be all set. Thank you, Mr. Mullally.
All right, thank you so much, Your Honor.
Then we have docket 25-01409. And you must be from Skyview, all right?
I am Mohammed Iqbal.
Okay, so you are Mohammed Iqbal, okay.
And Your
All
Honor,
right.
I'm here for Attorney Jeff Chip for the defendant.
All right.
My name is Matthew Clark.
So you can have a seat, Mr. Iqbal. So we're on the record in 25-01409. Appearances, you indicated, sir, you are Mohammed Iqbal, is that correct?
Yes, Your Honor.
All right, thank you. And for Attorney Jeff Chip, you are Matthew Clark, and representing Skyview Auto. Is that correct for the defense?
That's correct, Your Honor.
Okay. All right, this is the time set for a pre-trial in the matter. First things we can do is, I always give the parties, if the parties are amenable, you can meet and discuss any issues that led to the filing of this complaint. Mr. Iqbal, you're here in person. We could place you on an iPad and have you meet with, if he's amenable, Mr. Clark to discuss some of the legal issues here. Second thing we can do is just fill out a pretrial form that would set it would set the time scale, the time frame for this case. So Mr. Iqbal, I'll start with you. Would you like to meet with Mr. Clark, who's a representative of Skyview, or do you want just to fill out the pretrial order?
Just fill out the pretrial.
Okay, all right. And so we usually print it out, okay, and we'll get your signature on it. This is for 25-01409. It's Iqbal is Iqbal, and then the first name's Mohammed. Is that correct? And then the middle name is Saeed. Yes. Saeed. All right, and then that's Skyview Apartments, and you are representing Jeff Chip, and that's Matthew Clark. Is that correct?
Yeah, I'm here for Attorney Jeff Chip. Yes, Your Honor.
Okay. So with the captions, let me go through it. This is a breach of contract issue? That's what we use the form of it. Is it a landlord-tenant issue or breach of contract?
It's an issue for the car. I did purchase a car from them, and then by their information, I went to the bank and approved my loan, which I got approved.
So I think a general breach of contract would be a fair statement, Mr. Clark?
I believe so, Your Honor.
All right. And then we'll go from there. I'll set some date frames, times and dates, and we can go from there. Let my assistant type it all up, okay? Because they don't want to read my writing, right? All right, so Mr. Clark, I'm in possession of the pretrial statement for 25-01409. Pretrial conference was held on July 15th. Mr. Iqbal is versus Skyview Automotive, and we have is Matthew Clark, you're here for Jeffrey Chip. I'm gonna make sure that's on here. And you are representative of Skyview, is that correct?
Correct, Your Honor.
All right, I have issues of breach of contract, the pleadings, none or any additional pleadings. Do you expect any more, Mr. Clark?
You know, it was a pretty bare bones complaint. We don't need anything as far as, you know, further allegations. I'm assuming we kind of know what the issues are. I'm not expecting to change our answer. So unless the plaintiff is willing or changing his complaint, nothing here.
All right, and then Mr. Iqbal, you don't expect a change in or anticipate any change in pleadings that have been filed so far. Summary, of course, the motion for summary disposition and response can be heard at any time after today's date, but it's usually done through discovery, and I'll give you that date. We're not consolidating the case. There's no admission of fact at this time. That's not applicable since discovery is not complete. Exhibits are not applicable because discovery is not complete. We've set discovery for the cutoff date for discovery is October 14th of 2025. We roughly use about 90 days for discovery purposes. So in that time frame, Mr. Iqbal, you might be requesting some interrogatories or some discovery information is what you're getting at, is what I'm getting at, before October 14th, and you might get something from Mr. Clark in the same way. All right. Expert witnesses are not applicable because discovery is ongoing, and it's only up until October 14th. Damages have already been pled for. I'm not joining any claims unless either party has a contrary opinion. Mr. Clark, do you know of any joinder of claims in this?
I don't. No, Your Honor.
And Mr. Iqbal, you've not added any defendants. The defendant is Skyview Automotive. All right. Then has either party paid for a jury trial, or is this a bench trial? If you want a jury trial, a fee has to be paid. Mr. Iqbal, have you requested a jury trial in this matter?
No, sir.
All right. And Mr. Clark, have you requested a jury trial on behalf of Skyview Motors?
No, Your Honor.
All right. I'm estimating time for the trial would be 1 full day. It would be set after discovery closes by the civil department. Negotiations are ongoing. Does either party, Mr. Iqbal or Mr. Clark, do you see a reason for case evaluation or for mediation in this case? I'll start with the moving party. Mr. Iqbal, is there any reason for case evaluation or for mediation?
Only reason I did a case for because I had a couple things that when I bought the car and seemed like everything okay. And my brother is a witness. I was supposed to bring it with me, but he's at the job.
All right. This is a pre-trial, so he doesn't have to testify. But did you want to make this what I can do is that I can order mediation so you have the opportunity to have somebody else, a mediator, look at this, and maybe would you like that?
Yes, sir.
All right. Mr. Clark, do you have any objection to this being set for mediation?
I mean,
I usually set it. Okay, go ahead.
Yeah, I mean, I technically don't think this case will need. I think the discovery is going to flesh out the issues pretty well here. So I'm not sure whether the mediation will be useful, but I suppose, you know, is it possible to file a motion for summary disposition before the mediation, Your Honor? So that way there's not expense wasted with the mediator.
I would have the mediation before the motion for summary disposition, but I would set it mediation sometime after the October 14th discovery date, because I don't want either party to benefit from discovery through the mediation process.
Right. Okay. Because the only thing is I don't want, this to unnecessarily burden either party with a mediator fee that will be useless.
All right. I will set, if this is, I say for case evaluation, no, mediation may be set after 90 days, which would be after discovery.
Thank you, Your Honor.
And then, Mr. Ikbar, I'm going to have you look at this and sign this. And Ms. Labiak, if you make that available, you can take a look at that. And then, Mr. Clark, I'm going to ask for signature via Zoom, okay?
Sure. And hopefully I'll be able to figure it out. And if not, my signature is fine on it. Yeah.
Perfect. All right, Mr. Clark, can I sign the pretrial statement on your behalf for Mr. Chip via Zoom?
You may.
All right, I will sign this as district court judge. And then you'll each get a copy. Mr. Clark, we can mail it to you. And then if Mr. Ikbar, if you stay, we'll get you a copy of this already signed. And then we'll take care of signing and scanning the pretrial statement. Anything else for the record in 25-01409, Mr. Ikbar? Mr. Clark, do you have anything for the record?
Nothing further. Thank you, Your Honor.
All right, you're all set. Thank you for your appearance today.
Have a good day.
Thank you, Mr. Clark. You too. All right, so we're back on the record in docket 25-02425. That is Todd Dowrick versus Shrita Deering. And Mr. Dowrick, did you have the opportunity to speak with Ms. Deering in a breakout room?
I did. We reviewed the ledger and the judgment. I showed by looking at collectively looking at the ledger that the June 25th judgment is paid in full. There is a small balance due for July, but again, the June 25th judgment is paid in full.
All right. Ms. Deering, this is your motion to set aside the judgment. Did you want to go forward with the motion or are you satisfied after meeting with Mr. Dowrick?
We're okay.
Okay. So we'll withdraw the motion. After the parties have met. I don't know, civil might need an order for that. Yeah, we do so, but we'll take care of that. Whatever they need, we'll get it to them indicating that you withdrawn the motion and the parties have met on the case. And then we'll indicate that we'll entertain any future motions if there are any. But the consent judgment has the motion to set aside that motion has been withdrawn at this time. Anything else for the record in 25-02425, Mr. Dowrick?
No, sir.
Any question of me, Ms. Deering?
No.
All right, you should be all set. Thank you for your appearance today.
Thank you.
Thank you.
Thank you.